to figure that out real quick. Shouldn't be, is there? Maybe if we put it. There we go. There we go. Yeah, like 3.5 weeks. And I only have about 3.5 years to get my wedding body, so I'm in great shape. Yeah. That's right. That's right. I'm only 3.5 to 4 years away from my wedding in 3 weeks. That's right.
Commission meeting into session. And I think we've got a couple of items of business today. The first one is a HR review, HR policy review. But before we get started, I'm going to have the commissioners introduce yourselves. Starting over here.
I'm Alex Moore.
Manu Lee.
I'm Denise Klein.
I'm Trish Holland.
Tom McCormick.
Thank you. And so now we're ready for whoever is coming from HR to present the policies. If you would just introduce yourself also when you get up to the podium. Thanks.
Good morning, members of the Civil Service Commission. My name is Charnel Jones, and I'm the HR Director. As you are aware, you received a memo regarding the list of positions that need to be updated that are exempt from the Civil Service Act. The Civil Service Act requires that the Human Resources maintain a list of all positions that are not covered by the Civil Service Act. The last time that list was updated was in 2021, and I think that came to you all at that particular time. Just also want to note that all positions are covered by the Civil Service Act except for the following exempt positions as a reminder. Elected officials, employees or officials appointed by the city council or the city manager and approved by the city council and their immediate secretaries. It also includes department heads, division heads, and their immediate supervisors, part-time or non-permanent officers and employees serving their probationary period before becoming permanent employees, and any employee that is applying for a promotion in one of those categories that I mentioned earlier. In your memo, there was Exhibit 1 that included all of the positions that we were updating for that will be exempt from the Civil Service Act. Those new positions were highlighted on the list that you received. Also, as you are aware, we have a member that will be vacating, the Civil Service Commission, an employee elected member. And so in order for us to effectively do our election process, we will need to adopt a updated list of positions that are exempt from the Civil Service Act, because those individuals cannot vote during the election process. And so we are bringing that list to you all to review and to receive any recommendations that you have to go back to the city manager before we take that list to city council for final approval. So I don't know if you have any questions.
Yeah, have a question?
I don't have a question, but as Charnel noted, this was submitted to us, and I think we've all had a chance to review it. So just for discussion's sake, I would just go ahead and move we approve the list as submitted.
Second that.
Any questions or discussion about the?
Yeah, I just have one question. So the positions that were added, what is the purpose? Like a video production supervisor, why would that person be exempt from the Civil Service Act? Well, like what's the reasoning behind that?
That position falls in the category of a division head. We use our policy, which is the definitions, 300-1A, which was also attached as one of part of your exhibits. And any position that is directly reporting to a department head is considered exempt from the Civil Service.
And what's their recourse if they're exempt from the Civil Service Act? What's their recourse if they feel like they've been wronged by the city and have grievances?
They can still follow the normal grievance process that we have internally, and that's defined in our 300-18, but they just would not be able to go forward to the civil service. They will be able to go up to, depending upon the level of the grievance or the nature of the grievance, it could go up to the city manager, but it would not go towards civil service.
Okay, thank you.
Any other questions? All right, we have a motion to I send this forward. I guess we don't really have a lot of power other than to make recommendations, and I understand, Tom, your motion is to have this go forward. All in favor indicate by saying aye.
Aye.
Excuse me, Madam Chair, was there a second? I was out.
Yes, there was, and Commissioner Holland provided the second. All right, thank you so much.
Thank you.
We appreciate it. And now the next item for business today is the matter of Keith Heckman versus the City of Raleigh. And we are here today to hear the city's motion to dismiss and in the alternative motion to stay. And Ms. Smith, you're here, and if council would just introduce yourself, if you don't mind, for the record.
Yes.
Wait, hold on just one moment. Let's get everybody in place. Yeah, we are in the record now. Now, if council for Mr. Heckman and the city would introduce yourself, please, for the record.
Good morning, Kelly Stevens on behalf of Keith Heckman.
Good morning. I'm Ann Smith, representing the City of Raleigh.
I'm sorry. First of all, I didn't hear your names, so if you could please. I'm so sorry. My cord got stuck under my chair. If you could please repeat your names again, please. Kelly Stevens.
And please speak into the microphone because this is being recorded as well. At the back podium.
Be at the microphone. Okay, Kelly Stevens, Kelly. Stevens is Stevens.
And I'm Ann Smith with the City of Raleigh. And I just want to introduce as well, we have, I'm with Jackson Lewis. We have two summer law clerks, Anthony Bland and Destiny Shippey, so they just passed out your notebooks.
I can't hear you. Take this down for the record. You know what? I was here just a few weeks ago, and that particular microphone, you have to be really, really close to it. Otherwise.
Okay, is that better?
Yes.
Yeah.
Thank you.
Okay, and if I
didn't get what. Okay.
Sure. But if I get to a point where you can't hear me, please feel free to interrupt again, okay?
Oh, thank you.
Yes. So this is Anthony Bland and Destiny Shippey. They are summer law clerks with us at Jackson Lewis.
And Ms. Smith, we've been handed our exhibits for the city, is that correct?
Yes, that is correct. So we're here today to hear F5, here we go. The City of Raleigh's motion to dismiss. In the notebook, it contains the original grievance appeal that was filed, the motion to dismiss filed by the City of Raleigh, and the opening brief supporting the motion to dismiss, the response brief filed by Ms. Stevens, and then the city's reply brief. And you guys should have all received this information, I believe. Mr. Piccini had also distributed that via email. So again, we're here today on the motion to dismiss. So first of all, just as a general overview, Mr. Heckman filed his petition and he seeks to appeal two issues. The first is the city's transfer of him from the TARU unit, that's the Technical Assistance Response Unit, to field operations. So he was transferred from a specialized unit back to field operations. And then also he seeks payment of standby pay from June 2018, December 2020. And during this time period, he says that he was in the fugitive unit and the TARU unit, and he did not receive standby pay during those time periods. So the issues for the hearing today are, first, does the commission have jurisdiction to hear the grievance appeal related to the petitioner's lateral transfer from TARU to field operations? And then also, the second issue is his claim for standby pay barred by the applicable statute of limitations. And I know some of the members here were members back when we heard what I'll call the original standby case. And so you guys are well familiar with the standby policy, but for those who are not, SOP 307 is the city's standby policy. And it was adopted back in 1985, and here's a copy of the policy. SOP 300-7 is an exhibit to various briefs in your notebook. So if you can't see it on the screen, you can find it in your notebook as well. But basically, long story short, there was this big hearing about this policy, and ultimately the commission determined that the city's interpretation that you had to have a position designated to receive standby pay, and then that position had to be approved by the city manager. The commission agreed with the city's interpretation of that policy. So basically, you have to have a position that's been designated and approved to receive standby pay. Another thing that happened was during the course of the prior grievance, Chief Deck Brown, who was the police chief at the time, had issued a memo back on April 11, 2018, when she had reviewed the positions in the police department that were eligible to receive standby pay, and she decided to add some additional units to that list. That list did not include the addition of TARU or fugitive. And here's a copy of that memo. As you can see, this memo went to all personnel. It was dated April 11th, 2018. And it shows the additional units that were added to the list. Those are denoted by the asterisk, and then the list that, of positions that had already been receiving standby pay are listed on there as well. Again, neither TARU nor fugitive are on this list. So Mr. Heckman is a longstanding member of the Raleigh Police Department. He admits in his brief that he received a copy of this April 11, 2018 memo. So he knew as of April 11, 2018, that neither TARU nor fugitive were added to the list. We also know, based on his brief, that on September 8th, he was aware that his Lieutenant Godwin had sent a memo to Major Osterhout where he was requesting for consideration standby pay for TARU and fugitive. So we know that there was this issue within TARU as to whether they should be considered for standby pay or not. This memo was sent up. He was aware of it. Also, we know July 26, 2021, this commission concluded the hearing on the original standby case and issued its final decision in the prior standby case. So in December 19, Petitioner Heckman, rather, was a detective sergeant in TARU. And he said on this day his lieutenant called him up and asked him to bring in some members of his unit so they could assist with helping apprehend a subject. He called the folks. Only one person was able to come in. Everybody else said that it was the Saturday before Christmas. They had plans and they were not coming in. Even though they were on standby duty for that week. Sergeant Heckman asked his lieutenant if he could order those folks in. And Lieutenant Godwin told him he could not order those folks in. Even though they were on standby, they were not getting the standby pay, so they could not be disciplined or required to come in because they were not receiving the pay. And as a matter of fact, in the grievance appeal and the brief that Mr. Heckman filed, he admits that he had several conversations with folks, including his lieutenant and police attorney Alice Tejada, who all said, if you're not getting standby pay, you can't be disciplined for failing to report in. So on December 19th, TARU didn't show up. A few days later, the command staff met for an executive retreat to go over routine assignments and transfers. December 23rd, that should be RPD, sorry, that's a typo. The Raleigh Police Department issued a memo regarding the assignments and transfers, and Sergeant Heckman was transferred from TARU to field operations effective January 1, 2021. He contends...
If you could, I know you're probably reading, but I can't read and report at the same time, so just that last part, if you could repeat it, please. I didn't quite get it.
Sure. So on December 23rd, 2020, the police department issued this assignments and transfers memo, and on the memo it indicated that he was transferred, Sergeant Heckman was transferred from TARU to field operations effective January 1, 2021. Sergeant Heckman contends that his transfer was in retaliation for the failure to have his folks on TARU come in to assist on December 19th. So those are the basic facts. So there are some preliminary considerations here. First of all, As you're well aware, the Civil Service Commission is a board of limited jurisdiction, and the board is created by statute, and the board only has the authority which the statute says that you have. So in order to have jurisdiction to hear an issue, an employee has to basically allege two things: a violation of city policy, and that violation has to relate to a suspension, layoff, removal, promotion, forfeiture of pay, or loss of time. So it has to be both of those things. The Civil Service Act does have a specific provision which says that the Commission shall have no jurisdiction to hear matters involving lateral transfers unless it finds that the transfer was a demotion. So the transfer here would have to be a demotion in order for the Commission to have jurisdiction to hear this matter. So basically, as we said before, you've got to have two components: the violation of the city policy, and there's no jurisdiction if the transfer was a lateral transfer. Just generally speaking, a couple other things. The issues for hearing are only those issues that are raised in the hearing request. It's the petitioner who bears the burden of showing that the statute of limitations is met and that subject matter jurisdiction over the matter exists. And so here he has got to show that a violation occurred of city policy and that he was demoted. So let's talk for a moment about the transfer. First of all, what is a lateral transfer? This question is answered by city policy. Human Resources Policy, Personnel Program Policy Definitions 300-1A defines a lateral transfer as a transfer within a department to another department from one position to another of the same class, title, and or pay grade. So if you're transferred from one position to another and your title and pay grade don't change, that is a lateral transfer. There's also another policy, Human Resources Policy 300-4A, which provides that if employees who are transferred laterally to a job that is in the same pay range will keep their current pay rate in the new job classification. So this is just another indication as to what the city deems a lateral transfer to be. And again, this is another policy 300-4A. Policy 300-22 is another policy that speaks to lateral transfers, and this is a policy regarding recruitment selection procedures. And this policy basically says that the procedures don't apply to promotions or to lateral transfers of an employee of one position to another within the same job classification within a department. It also specifically provides that the policy is in no way to prohibit the lateral transfer or demotion of an employee at the discretion of the department head. Now, what is a demotion? Raleigh City Policy also defines a demotion. It's defined in Policy 300-1A, which says that a demotion is the action when taken when an employee is either assigned to a position or requests being moved into a position that is in a lower pay step or pay band than the position currently held. So basically, in order to have a demotion, your pay's got to change, and that's pursuant to city policy. If your pay doesn't change, it's a lateral transfer, and your allegations are going to be insufficient unless you allege that there's been a change in pay. So we know that Sergeant Heckman got a copy of this assignments and transfers memo. It was dated December 23rd. It was sent to all Raleigh personnel. In his grievance appeal, he makes these allegations related to his transfer. And let's look at what he says. He says, I was removed from a specialized unit back to a less desirable position in patrol, far from my home, and I lost pay and benefits of my position, and then I lost my police vehicle, my clothing allowance, and I had to incur expenses for travel far from my home to report to duty. So if you can look here, he doesn't allege that he lost any salary or that his salary changed. He also doesn't allege that his rank changed. As a matter of fact, he was transferred from sergeant in TARU to sergeant in field operations, so we know that it didn't change. He also doesn't allege that he was disciplined for failing to come in that night. He doesn't allege that his pay band or that his pay step was impacted. As a matter of fact, the only loss that he occurred was because he had his take-home vehicle taken away, his clothing allowance was taken away, and he had travel expenses to his work. So if you go back to that memo, the assignments and transfers memo, you will see that Sergeant Heckman is not the only individual who was transferred from the detective division to field operations. In fact, there were 4 other people who were transferred as well. And like the petitioner, every single one of these sergeants would have lost their take-home vehicle, their clothing allowance, and they would have had to incur travel expenses getting to their place of work. So here we know that Sergeant Heckman's transfer was a lateral transfer. The only thing that changed here was his division. He was transferred from TARU to field operations. His pay did not change. His rank did not change. He alleges that his benefits did change, but however, those are insufficient to constitute a demotion. If the commission were to entertain the fact that anytime someone's benefits, whatever they may be, would change, and that's enough to allege a demotion, then there would probably be multiple appeals from folks coming in saying this one thing in my position changed, therefore I've got a claim. And clearly that's not the intent of the Civil Service Act. In addition, we know that less desirable assignment is insufficient to constitute a demotion as well. We cited a couple cases in the brief which stood for this proposition. Basically, if you are transferred to a position that has less duties or is less prestigious, that sort of thing, it doesn't matter because you don't have a legal right to a specific job. So given these facts, the commission must therefore dismiss this case based on the lack of subject matter jurisdiction because Sergeant Heckman has alleged a transfer and not a demotion based on city policy. Let's talk for a moment about the standby claim. Again, he's seeking standby pay from June of 2018 until December 2020 when he was transferred back to field operations. Here's a copy of the standby pay policy again. Federal law allows employers to have folks on call, and those folks who are on call don't have to be paid pursuant to federal law. Here, the City of Raleigh has enacted this standby pay policy where some folks have been paid for standby duty and other folks have not been paid. And consistent with federal law, city employees can be placed on standby duty without receiving this additional compensation under SOP 300-7. And as again, you have to have the designation and approval process. And these processes have been in place for many, many years. As a matter of fact, going back to 1985, we see in this memo, former city manager Dempsey Benton sent to the department head saying, look, if you need somebody on standby to get overtime, I need to know about it, I need to approve it, we're going to maintain this list, this is the process that we're going to follow. Additionally, we know that this designation approval process has been in place because of Don Bryant's memo back in November of 1995. So this has been in place for a long time. Let's look at what the standby pay allegations were. He basically says, I was assigned to TARU fugitive. I did not get my standby pay. I want standby pay from June 2018 to December of 2020. And he said he experienced a forfeiture of pay for not being paid the standby. So some general principles regarding the statute of limitations, because that's what the issue is here. Basically, the statute begins to run as soon as the injury becomes known or should become known. Okay, so that's important. It should be known or can become known. Again, petitioner has the burden to prove that the statute of limitations does not bar his claim. And under SOP 318, that's the grievance policy. The grievance policy says that the petitioner has to file his grievance within 15 working days after the cause for the grievance became known to the employee. Well, let's look at what Sergeant Heckman knew. First of all, he knew as of April 11th, 2018, that neither fugitive nor Tehru were on the standby pay list. He received a copy of this. He doesn't dispute that. His argument was, well, I was not in fugitive or Tehru on April 18th, so I couldn't have made a claim. He admits in his appeal that he was transferred to fugitive in June of 2018 and then in Tehru in December of 2019. So he would have known as of June 2018 when he was assigned to fugitive, assigned standby duty, and did not get standby pay, that he would have had a potential claim pursuant to SOP 300-7. But, we don't even have to really get there because we know the Commission's already decided this issue, right? The Commission issued its final decision and entered a number of conclusions of law in that final decision. And I've listed out some of those conclusions of law here. And basically, this commission said, look, city, you're okay. You can assign folks to standby duty, and you don't have to pay them standby pay, and that's not a violation of city policy. There was a lot of days of hearing, there was lots of evidence presented, but basically that's what it boils down to. The city can assign folks standby duty without having to pay them standby pay pursuant to SOP 300-7. So we know that Sergeant Heckman filed his grievance on January 5th, 2021. But before that happened, Chief Deck Brown had issued a memo back in April 2018. He started working fugitive. He started working Tehru. He was assigned standby duty. He didn't get standby pay. September 8, 2020, his lieutenant even sent a memo saying, hey, let's get standby pay for the folks in Tehru. He knew about that memo as well, and during this whole entire time, he never made a claim for standby pay, even though he knew there was a potential issue where he could make a claim. Here, the petitioner tries to rely on the continuing wrong doctrine to say, well, the statute of limitations had never run here because the city is continuing to violate the petitioner's rights. The city didn't pay him standby pay when it should, so therefore his claim is never out of time. Well, first of all, you've got to show that there is a continuing wrong, and based on the Commission's decision in the prior standby case, there was no continuing wrong. The city's assignment of Sergeant Heckman to standby duty did not entitle him to standby pay. But even without that, the cases that are cited in the brief do not show any sort of continuing wrong here. If a promise to standby pay was broken, it would have been broken back in April 11th, 2018, when Chief Deck Brown issued her memo, or back when Sergeant Heckman was assigned to Tehru or fugitive and did not get the standby pay. And his failure to bring a claim at that time is fatal. Because of this, his claim is barred by the statute of limitations. He didn't file his grievance until January the 5th, 2021, even though he had years of notice that he had a potential standby claim. In their brief, Sergeant Heckman claims that, well, there is another statute of limitation that should apply. It's not the 15 working day statute of limitations in the grievance policy. First of all, the 2-year statute of limitation from section NC Gen Stat section 1-53 should apply. And this statute applies to an action against a local government upon a contract, obligation, or liability. I've got the language set forth up here. The problem is the commission is not a court, right? The grievant in this particular case, he didn't make a claim under the statute. If he wanted to make a claim under the statute, he could go to court and make a claim in court. But he didn't do so. He decided to file the grievance. He also posits that the 3-year statute of limitations set forth in NC Gen Stat section 1-52, subsection 2 should apply, because you can have a 3-year statute of limitation which arises upon a liability created by statute, either state or federal. So again, a 3-year statute of limitation should apply. However, again, commission's not a court. He could have brought a claim in state court had he wanted to. As a matter of fact, he even admits this on page 13 of his brief. He said if a city employee chose to do so, they could file a direct action against the city in state court and is not even required to make a grievance. So he knows that he could have pursued those claims in court. He didn't. He pursued the grievance. The grievance has a 15-day statute of limitations. That should apply. So his standby claim should be dismissed. If this commission decides that a standby claim should not be dismissed, then we would, in the alternative, ask that this commission stay the proceeding in light of the fact that there is a pending appeal of the original standby case. As a matter of fact, the city filed its brief just yesterday with the North Carolina Court of Appeals, so it'll be some time before we get a ruling on that. And so in the interest of consistent application of policy, conservation of commission resources, we would ask that there be issued a stay if you guys do not decide to dismiss this. But in any event, we do believe that both issues on appeal should be granted. Sergeant Heckman was laterally transferred. It was not a demotion. Because of that fact, this commission has no jurisdiction to hear it. And again, his grievance is well past the 15-day statute of limitations. So his claims should both be dismissed. So are there any questions?
Any questions from the commissioners?
All right, thank you.
Thank you, Ms. Smith. Ms. Stevens.
I'm not sure where I'm supposed to put that.
Ms. Stevens, before you get started, the microphone is like facing your forehead. Thank you. Good morning, members of the commission. I represent Sergeant Heckman. He is here today beside me. And the motion to dismiss should be denied where Sergeant Heckman was in the Technical Assistance Response Unit, which is a specialized unit in the Raleigh Police Department in the Detective Division. And he was retaliated against and transferred back to field operations in a position furthest from his home, simply in retaliation for not having his guys report in for standby duty when they were not receiving the pay for standby duty. And he has alleged in his complaint that he was retaliated against and lost pay and benefits and was removed from a specialized position back to field operations, basically patrol. Further, the claim for standby pay is not outside the statute of limitations, where the city was using a pretense that these duties were voluntary when in fact they were not voluntary. And the motion to stay is also inappropriate because I'm going to explain why this case is different than the case that was before the commission before, and is distinguishable and doesn't affect the other case that's pending on appeal. Ms. Smith did talk about a little bit about the prior case, the standby pay case, and that involved, that started in 2017. That involved 37 Raleigh police officers, and those officers were on the SWAT team, and the other set of officers were in the detective division. Just like Mr. Heckman, they were working in homicide in the detective division. They filed a claim against the city in 2017 stating that the city was violating its own standby pay policy in placing these specialized units on standby duty schedules and not paying them the standby pay set in City Policy 300-7. There were two violations alleged. One was that they didn't follow the policy first to get them approved before making them perform the duties, or second, that they were performing the duty and not paid. During the pendency of that prior case, one of the arguments that was made by the city was that the officers in these specialized units were different than the other officers. They were receiving additional benefits, they got perks, they got a car, they got clothing allowances, and they had other benefits, and they were in specialized units. They also, every witness had testified in the prior litigation, with the exception of the chief of police, that these officers were required to report in when on the standby schedule. And several of the police officers in that prior case testified about the culture in the department, and if you don't report in when you're on standby duty, you can pick your district, and there's threats of being transferred, and that was testimony in the prior case. The chief of police testified before this commission in December of 2020 and made representations to this commission, we would never transfer anyone. This is a voluntary duty, and we wouldn't transfer anyone or retaliate against anyone. Though the department did start paying the petitioners on the SWAT team and the homicide team back during the pendency of the prior case, apparently they did not pay TARU and fugitive teams that were also in these specialized units who were performing standby duty schedule. So I think they led the commission to believe that any issues regarding standby pay had been rectified when in fact they had not. During the pendency of the prior grievances, the chief of police did in April of 2018 issue a memo stating that she was going to start approving pay for these units. But in April of 2018, Sergeant Heckman wasn't performing standby duty. He had never been assigned to the TARU unit. He had never been assigned to fugitive. So when this memo came out to the department, it didn't even apply to Sergeant Heckman because he wasn't performing standby duty at that time, and this memo didn't apply to him. Now later, he did receive the assignment to the fugitive first, then TARU in December of 2019. He asked about standby duty pay, and the city made representations to him that the units that were not being paid were not required to report in, and the city was going to take this new position that if you're receiving the pay, you're required to report in, and if you're not receiving the pay, the duties are voluntary going forward, and you're not required to report in. So even though this conflicted with written police department policies that everyone was required to report in, Sergeant Heckman was told that the distinction between his position and the positions of the homicide and SWAT team is that it was voluntary, that they don't really have to report in. So in practice, in the police department during this time period in 2020, morale at the department was really low because the city was playing games with the provisions and they weren't applying them consistently. So employees were frustrated. So in December 19, 2020, Sergeant Heckman's guys on his team, they're frustrated. They're like, we're performing these same duties and we're not getting the standby pay. And in fact, when you looked at how many times people were being called in, the fugitive team was being called in 69 times, the homicide team 58 times, and the SWAT team 35 times. And homicide and the SWAT team were receiving the standby pay, and fugitive and Taru wasn't. So of course, when eventually this is gonna come to a head. And this happened on December 19th, 2020. These units had always reported in, but they got a call close to Christmas saying that they needed to apprehend 3 heavily armed gang members, and the team needed to come back in. They were on standby duty. And these guys said, we have plans. It's Christmas. They all had plans. We're not being paid standby duty, so we're not coming in. So his guys said they're not coming in. So he calls his direct supervisor and says, I don't have anyone that can come in except one person, and that would be dangerous to have one person try to apprehend 3 heavily armed gang members. So he asked his direct supervisor, Lieutenant Goodwin, can I order my guys in? And they said no. But Lieutenant Goodwin became upset and angry. You need to get your guy, there was this back and forth. They need to come in, and they're angry. They're saying it's voluntary, but they're expressing anger towards my client. There was several conversations, and then it went up to the person that approved his transfer, and this is in the city's answer. I don't know how to pronounce this. Deputy Chief Osterhout. My client was told that his Lieutenant Godwin was on the phone with Deputy Chief Osterhout. He was going to be angry, and they needed to come in. He needed to call them again and have them come in. And the petitioner said, well, I'll order them in if you tell me to. And then basically no one got back to him. And 4 days later, he was notified, you're being sent back to patrol, a district furthest from your house. Not only did they do that, but the city started giving him conflicting reasons for the transfer. And this is all in writing. The city issued a memo accusing him of poor judgment and citing 3 instances of poor judgment, which the city failed to mention in his answer. And that's in my brief, but I want to talk about just generally about that. First, he was told that they didn't know why he was being transferred. Then they said that he would exercise poor judgment in having blue lights in an undercover vehicle in May of 2020, many months before his transfer. And those lights were in the vehicle and approved to be in those vehicles by city policy before he even worked in the unit. They accused him of conducting a knock and talk without appropriate backup in May of 2020, and my client wasn't even working on that date. They accused him, he has worked a knock and talk before, but he had 10 guys as backup, so that was a completely fabricated reason for his transfer. And this is all in writing that he would present if we have a hearing and evidence. They argued he had a dispute with his neighbor when Wake County Judge Eagles, there was a woman in his neighborhood that was complaining about all these people, and Judge Eagles threw that case out. And so they're literally fabricating reasons for his transfer. Once he was able to document that all these reasons didn't apply to him, then they said, oh, well, it was just a routine transfer, and then they changed their mind again. So this was not a routine transfer. The city can clearly promote people, transfer people, but they can't do it in retaliation for my client trying to follow city policy. And he has alleged this in his answer. Ms. Smith mentioned that 3 other employees were transferred to patrol like Sergeant Heckman, but these employees were lower level employees that actually were promoted. So they were promoted, they were sent to field operations, but they were given promotions, greater pay, and they were in supervisory roles. So that's a distinction between these employees that were transferred. So the Civil Service Commission, by the statute, clearly has jurisdiction to hear a matter of a lateral transfer that is really, in effect, a demotion. It says that in the language of the statute. There were 2 cases that the city was referring to in its brief. in arguing that a lateral transfer could never be a demotion. And they cite to two cases. One case was the Gibbs case, the Gibbs versus Department of Human Resources, and the second case was Winbush versus Winston-Salem State University. Both of those cases involved lateral transfers of state employees under the State Personnel Act. And those cases were heard before the State Personnel Commission, which did have hearings for those state employees. The difference here is that Sergeant Heckman is not a state employee. He is a city employee, so he's governed by the Raleigh Civil Service Act. And the language in the State Personnel Act and the language in the Raleigh Civil Service Act are different. So there is no language in the State Personnel Act that there's jurisdiction to hear lateral transfers if in effect it was a demotion. So that doesn't apply to Sergeant Heckman. Also, the facts of those cases are different than the facts of this case. In the Winbush versus Winston-Salem State University case in 2004, this dealt with an athletic director who was alleging he had been demoted or retaliated against when he was transferred to a new position, and he argued that he was supposed to receive a 10% raise had he not been transferred, and the court held that because it was a future benefit he had not received yet, that they hadn't behaved improperly. So that case was different because it dealt with a future benefit that the employee wasn't receiving. Neither case they only talk about base salary. They don't talk about the additional benefits that are in someone's paycheck being in the specialized unit. There's pay in their paycheck for the clothing allowance. There's the car benefit, and there's other benefits to being in a specialized unit. And so neither of those cases had facts that are like the facts in this case. Finally, those cases that the city argues allowed those employees, those state employees, to have a hearing. In fact, one of them, the same thing that the city is doing here, in one of the cases, they argued that the case should be dismissed because it was a lateral transfer. And the court said no, that once you allege a demotion, then the court assumes jurisdiction, and then we hear the facts, and then we decide whether there was a lateral transfer or not, and whether it was an effective demotion based on the facts. So a motion to dismiss is not proper, and that's specifically stated in those two cases cited by the city. Further, there's two cases that are more recent than the cases cited by the city that I cited in my brief. One is Salkowski versus Peters, and the second case is Alexandro versus the Secretary of U.S. Department of Homeland Security. The Soleski case was a 2007 case, and the Court of Appeals, U.S. Court of Appeals, held that the reassignment of a female executive in the Federal Aviation Administration from supervising 960 employees and a $400 million budget to supervising only 10 employees with little or no budget was an adverse employment action, and that the lateral transfer could constitute adverse employment action even if she did not suffer a loss in her base salary. And then this Alexandro case is one from March 2023, and that was on page 10 of my brief that I discussed this most recent case. And basically, in that case, it says that allegations construing a complaint in favor of the plaintiff, as the court is required to do, to give a plausible inference that a reassignment with significant different responsibilities can result in a claim for adverse employment action, and in that matter denied a motion to dismiss. So all of the cases, whether when you hear the facts and you hear the evidence, you may decide it's a lateral transfer. You may not award Mr. Heckman anything, but it still has to be heard. So the city they don't get to determine whether this was a lateral transfer or whether it was really an effective demotion. So the motion to dismiss is not proper, and he should be entitled to a hearing. I want to now talk a little bit about the statute of limitations issue. The city grievance procedures state that a city employee can should file a grievance within 15 working days, either after the cause for the grievance becomes known or after the occurrence of the issue giving rise to the claim. The city has argued a few times that Mr. Heckman should have known about the standby pay dispute because of this memo in April of 2018, but that's not the standard in city policy. City policy is he should make a grievance when it becomes known to him or after the occurrence of the acts giving rise to the grievance. So I first want to talk about his knowledge of, did he file a grievance within 15 working days after the grievance became known to him. I want to talk about that option first, to file a grievance. And when he basically wasn't employed or on standby in April 2018 when this memo was issued. He was later told that the duties were voluntary. It was only on December 23rd, 2020, when his direct supervisors were becoming angry with him, that he realized that this isn't really voluntary duty. And that is when he realized he had a claim, and that's when he immediately filed a grievance. So he can file a grievance on that basis. Second, his grievance for the standby pay would never be outside of time, because I have argued this case of Marsick versus NICO, which is a continuing wrong doctrine. And the reason that his claim would never be outside of time is that every time the city weekly was placing these employees on standby and not paying them, that was a continuing violation of the policy if in fact it really wasn't voluntary. And so that's the continuing wrong standard, and it's cited in this Marsick versus NICO Inc. case. And in that case, is on point because it actually talks as a wage case, and it talks about someone that was owed wages. It was a vice president of a company, and they stopped paying him his monthly salary benefits, and that happened in like 2002, and he didn't file a lawsuit until 2008. And initially the trial court said, well, you're outside the statute of limitations for wages is 3 years, you're outside of the time limit. The Court of Appeals reversed and said that he did have a claim under the continuing wrong document, and it says our Supreme Court has recognized that the continuing wrong doctrine as an exception to the general rule that a claim accrues when the right to maintain suit arises.
When you're reading, if you could read a little more slowly, please.
Okay.
Court of Appeals, continuing wrong doctrine.
Yeah, it says our Supreme Court has recognized the continuing wrong doctrine as an exception to the general rule that a claim accrues when the right to maintain suit arises. And under the continuing wrong doctrine, the statute of limitations does not start running until the violative act ceases. So the act that my client is saying was wrong is the act of placing him on a mandatory standby duty schedule and not paying him, and that continued because the pay would still have been owed. And there's also a new violation every single time. I mean, when he made his complaint in December of 2020, the week of Christmas, you don't count weekends, you don't count holidays. These employees typically have about 3 weeks to make a claim. They put him on standby weekly. So the city wants to argue that a memo by the chief is the violation. That's not the violation. The chief of police can issue 20 memos. The violation is placing an employee on a mandatory standby duty schedule and not paying them. That's the violation that keeps continuing. And so he's not outside the time limit to complain about that. Further, I think this concept that this 15-day grievance procedure is a statute of limitations is wrong, because a grievance procedure is not a statute of limitations. The statute of limitations in this state are set by statute. The Sherrod case cited by the city, again, deals with the State Personnel Act, and nowhere in that entire case does the court use the word statute of limitations. All the court says in that case is that the person didn't meet their appeal deadlines for a grievance. It had nothing to do with the statute of limitations. If the 15 working days was statute of limitations, then this commission could never award back pay for more than 15 days. Like every case you heard, if you didn't award a back pay, it'd be for 15 days. That makes no sense. The statute of limitations in this state are governed by statute, and where the Civil Service Act actually gives the commission jurisdiction to award back pay and salary adjustment, it doesn't state a time limit. And when it doesn't state a time limit, then one of the other two statutes in this state applies, which I talked about in page 13 of my brief. It could either be 152, or which is 3 years statute of limitations, or there's another statute that talks about claims against a municipality as a 2-year statute of limitations. But separate from the arguments about the statute of limitations, determining a statute of limitations is based on facts. And the facts have to be determined by evidence with a hearing. So again, the city's kind of jumping the gun and wanting you to dismiss the case when my client hasn't had a chance for a hearing, so that you can make these factual determinations and make these factual findings on both issues as to whether this lateral transfer was actually a demotion, and second, whether, was he outside of time to make a grievance or not. And so I think those are issues where he's entitled to have a hearing, and it would be improper to grant a motion to dismiss. As far as the motion to stay, this case I think is different because the other case that was heard by the commission did not involve any retaliation against any of the employees. It didn't involve employees that were specifically told your duties are voluntary, but now we're going to retaliate against you when you don't report in. And also the city created this problem. They had notice in 2017, we have the standby pay policy, you need to be in compliance with it. The city's had plenty of time to get into compliance, and they wouldn't have this case before it if they just complied and got everything straightened out. So the city is the one that's put itself in this predicament of potentially having different decisions. And I do want to point out the prior decision was a split decision. There were some members of the panel that thought the city was violating policy, and it is on appeal. And so I think that this case can still be heard because this involved an actual retaliation and transfer of the employee. I do want to point out that the city takes some inconsistent positions. In the first case, when because Sergeant Heckman actually filed his grievance before the commission actually issued a ruling in the other case. I tried to ask the commission to take judicial notice. Hey, there's another case pending. The city objected on the record and said that case is different. It's not related to this case. And now today, now that you couldn't consider it in that case, now they're saying, now the case is the same. The prior case, they said that this detective division, these are specialized units with special benefits. Now today, they're standing before you saying, there's no difference between being in a specialized unit and on patrol. The city also has argued federal law and that they don't have to pay standby pay. I disagree with that. Federal law is actually pretty complex on the issue of when you are required to pay or not pay for standby duty. There's like an analysis you have to do. Obviously, you're not a federal court of general jurisdiction, and I don't think that it matters whether federal law requires standby pay or not. The city council passed a standby pay policy, and that's what the issue is. So for the reasons that I've stated, I think that the motions should be denied. Yeah, I'm just looking to see if there's any other. Yeah, and that's all I have unless you guys have questions for me.
Are there questions?
just one point of clarification question. So, is the petitioner arguing that there was a reduction in the pay?
Yes, but not the base salary. But he did, if you compare a pay stub with a pay stub, there would be a reduction in pay because there were perks and allowances that he received in his position. So just as one example, like he would get about $792 a year for clothing allowance, but he also had the use of a vehicle, and by them, and that probably cost him about $8,400 a year. Him driving now he's driving his personal vehicle all the way to a district very far from where he lived. So I mean, that would have to be developed through his testimony as to the different benefits that he lost. But he has alleged that in his petition for administrative review. He has alleged that he's lost pay, in addition to the coveted position of being in the specialized unit.
Thank you.
Ms. Stevens, I do have a question. With regard to, without regard right now to addressing the standby pay part of Sergeant Heckman's appeal, with regard just to the transfer piece, how do you address the statute of limitations argument that the city's making just as to the transfer? So my understanding is the transfer happened in December and the appeal or the grievance was filed in April.
No, that's not correct. The grievance procedure started when he filed. I think what you're looking at is the date of the final stage of appeal from the city manager to the commission, but he actually filed the grievance with the city within a few, 3 or 4 days.
Okay.
And then that's documented. That's just not into evidence yet. The different stages, like the things I'm talking about, where he used poor judgment, that would have been in these memos as he was appealing through the city human resources city manager before it made it to the commission. So no, I don't think the city's arguing that he's out of time for that side of it.
And then second question is with regard to the retaliation claim. Is there a policy or anything in the city code or policies that reflect that a retaliation claim gives this commission jurisdiction?
Yeah, I did discuss that in my brief, that the city policy, let me see if I can find it, but city policy does state that employees can't be retaliated against for asserting their rights under city policy, and I thought I put that in my brief. But I know that, and then of course the statute itself says that the jurisdiction of the commission, the purpose of the commission is to hear employee grievances regarding, transfers, demotions, terminations, anything like that. So generally, I think you have jurisdiction based on the statute, but there's other actual city policies that would be entered into evidence talking about that the city shouldn't retaliate against employees for trying to follow policy.
Okay, and is that in your brief?
I thought it was. I'm having trouble finding it right now. But
And if you want to just wait, we'll hear from the city.
I
and
can
you can bring that back up.
Yeah, and I
like.
can. I'll review my brief to see if I quoted the provision, but I know that I used it whenever in the prior case. When we started those grievances, I had sent the city a letter stating, this policy says you can't retaliate against my clients because they're making this grievance. So,
okay. Thank you. Ms. Smith, do you have any further comments?
Yes, just briefly. I won't take up too much time. First of all, in reference to your question, Chairman Klein, I am not aware of any city policy other than the city policy that says you can't be retaliated against for making a harassment or discrimination claim. I'm not aware of any city policy that specifically prohibits retaliation. And the only policy that is somewhat referenced in this section of the appeal, Sergeant Heckman's appeal, is SOP 300-7. And I could pull the policy up again, but that policy speaks to nothing about retaliation. So there's nothing about retaliation in SOP 300-7. So here, there has been no city policy identified which would prohibit alleged retaliation. Of course, we contend this was not retaliation. We contend that the transfer had absolutely nothing to do with the events of December 19th. The transfer occurred because the command staff felt that Sergeant Heckman could benefit from working on his supervisory skills, and also field operations could benefit from his investigative expertise, and so those were the two reasons why he was transferred. So again, without identification of that city policy, there can be no retaliation. The commission does not have jurisdiction here because there has not been a city policy that's been violated. And the city policy, in terms of the lateral transfer, clearly defines what a lateral transfer is. It clearly defines what a demotion is. Sergeant Heckman's admitted that his base salary didn't change, so this was a lateral transfer based on the facts admitted here. You don't have to have a hearing if there are facts sufficiently admitted that would deprive this commission of jurisdiction. So that's exactly what happened in reference to this demotion lateral transfer case. Also, Sergeant Heckman's argument is basically, I said the magic word demotion, so I get a hearing so you can hear my evidence about that. But again, we've got admitted facts here which would deprive this commission of jurisdiction. And then in reference to the statute of limitations issue, if you want to call it statute of limitations issue, if you want to call it grievance appeal issue, whatever you want to call it, it's clear that SOP 300-18, which talks about the grievance process, it's clear that there's a 15-day working day limitation there, and that the employee has to file the grievance within that 15-day time period. And so failure to do that would prevent his grievance from going forward, and we contend that's exactly what happened here.
And just to be clear, and I apologize for being unclear about this, but the city's position with regard to the time limitation, you're not saying that he did not timely file the transfer demotion/demotion claim, but that he failed to file timely the standby pay. Is that
That's
right?
correct.
Okay.
The standby pay claim, because it would have accrued, beginning June 2018, and he had, almost 2 years to file his claim, and he failed to do so. So again, the motion to dismiss should be granted. Yes, sir.
Yeah, so I just had a quick question. So would you say that I'm interpreting the Civil Service Act correctly right here? I think the plaintiff side sort of alluded to this, but does it mean that the commission has the responsibility or authority to find that any sort of lateral transfer can be considered a demotion instead? So in other words, is that our responsibility to find that, and how exactly would we find that, if so?
So, again, I would point the commission back to the definitions of what a lateral transfer is and what a demotion is. So maybe in a different case where if we didn't have facts that were alleged like we do here, there might be an evidentiary issue as to whether the position was one that was a transfer or whether it was a demotion. But here, he's clearly indicated that his base salary did not change, right? And that's what city policy says. Basically, you have to show in order to be able to show a demotion. And so consistent with city policy, because he's admitted that his base salary didn't change, it's just all this extra stuff that really is compensated anyway in patrol, because only that stuff changed and his base salary didn't change, there has not been a demotion pursuant to city policy. I'm not sure if I answered your question.
Sort of, yes.
So I'll jump in here because I'll kind of give my thoughts and I'll let you respond to them. So the Civil Service Commission Act says, in effect, a demotion. It doesn't say in fact a demotion. And so I think that that wording is very intentional when it says in effect. And I think that gives the Civil Service Commission purview to see if a reasonable person would think that this lateral transfer is in effect a demotion, because you focused specifically on what legally is a demotion and what the city classifies as a demotion. But I think that word in effect gives us leeway of the city trying to circumvent what is technically, or what is legally and by policy a demotion, and that wording in effect gives the commission purview to look at it to say, would a reasonable person consider this a demotion? Because, you know, in my opinion, in his forfeiture of pay, and I think everybody here, when they're looking at a job, it's the base pay is one thing, but every reasonable person isn't looking at just the base pay. You know, if you're a salesperson, you're looking at what your base pay is and then what your commissions are and what you're walking away with at the end of the year. And so I think the petitioner's argument that, yeah, my base pay may not have changed, but benefits and all those things, those are real costs when taking into account the total compensation for a job. So I think the wording in effect, because they could have said, you know, if it is in fact a demotion, but I think the wording in effect gives us purview to be able to dig in to see if a reasonable person would view that as a demotion.
So even if that is the case, you still have to show a violation of city policy. And the petitioner has not shown a violation of city policy here.
Well, sure. He argued that it was a retaliation, and they've brought up, you know, because a lot of times when the city brings in a motion to dismiss, unfortunately, you know, I sit up here and I look at the petitioner, and they have a compelling case, but they didn't allege a violation of city policy or stuff like that. In this case, I feel like the petitioner is on the right track of alleging violation of city policy. And again, a lot of times we get caught up of, you know, was it written down in the form submitted to the Civil Service Commission, and a lot of times we have to say, yeah, you didn't include that claim in the petition to the Civil Service Commission, but he did allege that there was retaliation in that he was you know, asked to do something. He said, do I have to do it? And then there was retaliation to that. And so I think the petitioner has piqued my interest enough to move this to a full evidentiary hearing to hear his arguments. And now you may, and the city may take the position in the midst of this evidentiary hearing that we still want to deny this, but I don't think the city, for me, has provided enough evidence to make this a clear cut, you know, the commission doesn't have jurisdiction. I think there's enough of an argument on both sides that it's kind of piqued my interest.
So let me speak to these monetary issues again briefly. You know, he alleged he lost his take-home vehicle. Field operations, you don't need a take-home vehicle because you drive to work and you get a patrol car.
Sure.
In the clothing allowance, if you're in field operations, you have a uniform that you're issued, so you don't need a clothing allowance. And there is no guarantee to be close to your place of work. There's no guarantee of that. And again, the petitioner hasn't cited any violation of policy. He's just said garden variety retaliation here. SOP 300-7 doesn't address retaliation. It doesn't say that you can be, that you're protected from retaliation if this statute, if the SOP is violated. It doesn't say anything like that. And other city policies definitely say that in this particular case, on the facts admitted, that because the base pay did not change and because his rank did not change, these other incidental benefits may have changed, but that's a lateral transfer. It's not a demotion. And again, if you have an employee who says, well, who's transferred and anything about their benefits changed, their computer's smaller, they've got 2 monitors instead of 3 that they used to have, and they're saying that that's retaliation, is that enough to come to this commission and say, this was a demotion because my computer changed? I don't think so, particularly when demotion and lateral transfer are defined by city policy.
You know, I have to agree with Commissioner God.
More.
Yeah, more. Sorry about that. With the comments that he just posed, I think that we have enough to sort of go forward to an evidentiary hearing and sort of figure out if this was in fact a demotion or not. But I do have to agree with the city side that that there is this sort of precedent that we have to be aware of, right? That if we do allow this to go forward, can there be an argument made for every occasion where benefits change relative to a lateral transfer and whatnot? But in all, I may have misinterpreted the plaintiff's representative on this, but I think she alleged that there was a change in the base pay. I'm not sure if she could come and speak on that for a moment, but
I thought she just admitted that it did not change.
So what I represented, which again, Ms. Smith can't give testimony. So that she's standing up here giving all these facts, but that's not evidence and that's not testimony. What I stated was that my client's base pay hadn't changed, but if you compare the pay stubs, there's a change because of other additional benefits. And I found in the brief where I discussed on page 14 of my brief that city policy allows the employees to bring problems to the attention of management without the fear of reprisal. That is the policy I'm referring to. I don't have the specific number because, this is a motion to dismiss. My client filed. He's alleged retaliation. We would present that actual city policy at a hearing. But he was going to his management. Do I have to get my guys to come in or not? He's trying to follow city policy, and they're getting angry with him and retaliating against him. So I do think he has met his burden of showing that he should be entitled to a hearing. He's alleged in his complaint that he was retaliated against and that this was in effect a demotion. And what would be the purpose of this language added to the statute that says that the Civil Service Commission can hear information about lateral transfers if they are in effect a demotion? Why include that? If you're going to say in every single case where the base salary is the same, we can't hear it, then there would be no reason for that language in the statute. And that language is different even for state employees. So this is special language that they've decided to include to allow, probably in this specific circumstance where the city might be playing games and, this was a lateral transfer. Well, really, was it? So I think that he is entitled to a hearing. And as far as the case that talks about, this is the Winston-Salem case that the city quoted, this exact issue was decided by North Carolina courts because in that case, they had a hearing, they allowed the state employee to have a hearing, and they found that that employee wasn't really demoted. But what the court said is that they properly denied a motion to dismiss because when the employee alleges a demotion, in essence, the court held that the allegations invoke the jurisdiction of the Office of Administrative Hearings and the State Personnel Commission. So in that case, they literally said, the Court of Appeals in North Carolina, that it's the allegations that invoke your jurisdiction because then you can decide, was this in fact a demotion or not? So that's clearly established by case law.
I'm so sorry to interrupt, but is what you referred to in reference to the retaliation allegation, is that in the city binder or?
Well, the city prepared that binder, and no, they didn't put in evidence that's favorable to my client, no.
If I may ask Ms. Stevens a question. You said the pay stub showed differences, and you mentioned other benefits. What are the other benefits other than the uniform allowance? Because the car doesn't actually show up on your pay stub, does it, one way or another?
My client, I don't know that answer. I know that
my question is, we've just been throwing the word benefits, other benefits around, and so far the only possible connection there seems to be the uniform or the clothing allowance, which,
Yeah, so that's equated to a monetary amount. Yeah, the clothing allowance. I don't know what the testimony would be about the vehicle and how that was handled.
okay, and what, and what is the exact, I'm becoming unclear, what is the exact relief that Sergeant Heckman would like to receive?
Well, at the time when he filed his grievance, he wanted to be reinstated to his position back in that unit. But so much time has passed, he has since retired. But I mean, if you, it's, I mean, the reason that this board exists is these employees have a right to not be treated a certain way by the city. The city needs to follow its policies. I mean, you might award him $1, I don't know, but he has a right to a hearing because he was retaliated against. He was taken out of his position, and he's alleged this at what's been 2.5 years because these things take time and it hasn't been put. I mean, we asked for it to be set many times following the year that he was transferred, and the city kept arguing that they didn't want to hear the case yet. So, I mean, those are good questions, but I think it's based on the evidence. Can I just briefly mention about the statute of limitations? I'm going to try to give an analogy about a claim. So let's say there's a boyfriend and girlfriend in a relationship, and the boyfriend assaults the girlfriend. He's got anger management issues. During the relationship, he gets angry maybe once a week, and he assaults her and physically hits her. Maybe he even sends her a text: if you don't, do what I say, you're going to get it. It's coming to you. I'm going to hit you some more. And he does this for a period of 2 years, and she never complains. She never files a lawsuit. So let's say he hits her on Monday, and she finally says, "I've had enough. I'm suing you for assault." You can't argue, well, the assault started 3 years ago. You're outside your statute of limitations. He's hit her again. So that's what I'm trying to say. The violation keeps happening again and again. It happened the week before he filed his grievance. The difference between, and that's not a perfect analogy, because in an assault case, once you assault someone, that incident is over. But in a pay case, it's not over, because the Court of Appeals in the Marsick case said that when you're dealing with pay that might still be owed, that violation never stopped. It's a continuing wrong because you still owe the back pay, which is why this vice president was allowed to sue for back wages. And the Court of Appeals said he could sue even though it had been 8 years since they paid him, because pay is different. So that's what I'm trying to explain with the statute of limitations. It's not like, oh, Chief Deck Brown issued a memo and now that's the violation. That's not the violation. The violation is placing these officers on standby duty. They have to come in mandatory 68 times and they're not receiving the pay, but the city's saying, oh, it's voluntary. That's the violation. It has nothing to do with the memo.
Are there other questions? Ms. Stevens.
One question I have, Ms. Stevens. If, setting aside whether this was a lateral transfer or not, if we respectfully disagree with your argument on the statute of limitations, does that resolve this matter?
No, because they're two different issues. There's the transfer.
But how does that survive if the statute of limitations was missed?
Well, he didn't miss the statute of limitations. He filed his grievance within 3 days of the transfer. That's what the city just admitted, that he's not out of time for that issue.
Okay.
And so to follow up on that question, if in fact the transfer claim is fine because he filed within 3 days, then would the statute of limitations, so I guess the question is, does the statute of limitations issue only apply to the standby case?
Yes, that's what the city has said in their brief, and I think that's what Ms. Smith just told you. That's the statute of limitations they've raised as to the standby pay issue. And my opinion on that is, by city policy, he could file a grievance when it became known to him, and it didn't become known to him that this wasn't voluntary until they became angry at him and transferred him. Because if it was truly a voluntary duty, they wouldn't have treated him that way. So that's when the light bulb goes off and he's like, wait a minute, you're making misrepresentations to me. This isn't a voluntary duty. And that's another way that the statute of limitation can be told is through misrepresentations and fraud. That's clearly established under our laws in this state. So I'm simply saying, even when you talk about a statute of limitations, it's still a bit fact-based, and you have to hear evidence. What I'm saying is not evidence. What Ms. Smith is saying isn't evidence. We're giving arguments. So, I mean, even determining and for you to debate among yourselves and determine, well, what is the statute of limitations, I think that has to be decided based on what is the actual evidence.
And so I have one more question, which is, are you arguing before this commission that the state's court limitations in the general statutes will always apply to these hearings, and basically render the 15-day policy limitation moot?
Yes, because a statute takes precedent over a city policy, which Chairman Reeves also used to say many times, and when I was before him, that if you have a conflict between a statute and a policy, the statute's going to govern. And also, I believe this commission has awarded, they've awarded 2 years of back pay to someone before. So it doesn't make sense that the 15 days is a statute of limitations, and when he was required to file his grievance regarding the standby pay, that's based on facts. When did it become known to him, or when did the occurrence occur? Even if you felt he should have complained earlier, he was on standby duty then in the 3 weeks before his grievance was filed. So maybe he's limited to 3 weeks. Maybe you would find, well, he can only get if we find that the city was violating their interpretation of standby pay, maybe he's only awarded 3 weeks. Again, that's based on the facts of the case, but he's never outside of this 15-day working days because of weekends and holidays. That's about 3 weeks. He's placed on the duty again and not paid. It starts over again.
And I do understand the argument about continuing wrong. My real question is how the statute of limitations, the statutory statutes of limitation apply by their definition to court cases.
Yeah, I think that they do apply to the commission when you're awarding back pay, because the particular statute giving the commission the authority to award salary adjustment and back pay doesn't state within the statute itself how long you can award the back pay for. And there's another statute in North Carolina, which I've cited in my brief, that clearly states when the statute creating the right to give the award to an employee of the city is silent on how far back you can award back pay, then the statute governs of the 2 or 3 years. So I do think there's a limit. You can't reward him 20 years. I mean, definitely not. But this 15-day isn't a statute of limitations. It's a grievance procedure guideline.
So may I ask this question? Is there anything preventing your client from going to court and arguing these within the statute of limitations in a court case versus this body of limited jurisdiction?
Well, the city has, I think when we started appealing the other standby case, the city made representations to the Wake County judge that, the employees can sue in Superior Court. He hasn't chosen to do that. I mean, litigation's expensive. But I think that you might have what I would say dual, parallel, potential different ways that you could enforce a wrong. So maybe you can file with the commission, file a grievance, maybe you can file a lawsuit in Superior Court, but they're both, obviously one's way more expensive than the other, but I think they're mutually exclusive.
They're mutually exclusive?
I think you can do both, either or, is what I meant to say.
So you talked about, and I forget the legal jargon that you used earlier, about You wanted to include this case with the prior case, because one of the city's arguments is that, well, the commission's already decided the standby pay case, and so this, it's the same, right? And so your argument was that you wanted to include this case with that standby case, and the city said, no, this is completely different, so you can't include it with that case. Am I understanding you right? And then now they're arguing, no, it is the same, so it should be dismissed because the commission already decided the other one, or issue the stay until the other one's decided.
So factually what happened is we were on break. Like the former case was heard in a bunch of different hearings. So we were on break. That case had not been concluded when my client was transferred. When this new case came up. Sure. We had 1 day of hearing left. I think Chairman Reeves had been trying to retire for like a year and a half. There was like this immediate directive to the attorneys, we need to get this case finished this day. So the way that I thought was best to handle it, which would be the most, I say, expedient and time, it wouldn't postpone the hearing, was I just was asking the court to take judicial notice. There was this other case. There's a record with the Civil Service Commission that had been filed alleging that one of the employees had been, transferred. And all I was asking was that the commission just take judicial notice, hey, there's this other case out here, and the city immediately objected on the record saying I couldn't discuss this other case, it wasn't related, it was a totally separate case. Now they're arguing the opposite, that now, we can't hear his case because of the other case. Okay. So that was all I was saying.
Okay, yeah, that's perfect, because I want to hear the city's response to that when we get a chance.
Thank you.
Well, the big difference, of course, is the other case is now decided and now has become some level of precedent. I mean, that's the difference. So.
Ms. Smith, do you want to respond?
Just briefly, I don't want to belabor too many issues, but in the brief that Ms. Stevens said that she was referring to a policy about no fear of reprisal, that's actually contained in the grievance policy. So obviously he's claiming the retaliation occurred before he filed his grievance, so you can't point to the grievance policy itself as the basis for the violation of city policy governing retaliation. There's that, and then Mr. Moore, you had a question about the prior case.
How the city's on record saying that this case couldn't be included in the prior case because it was completely different, and now the city's saying this case, the standby pay should be dismissed or a stay ordered because it's very similar to the other case.
So in reference to the fact of taking judicial notice, I mean, this was a different case. It does deal with different issues. The transfer issue, the demotion issue, that was significantly different. The prior case, when we were talking about or deciding the standby pay issue, if we had our facts, we had our stipulated exhibit, we had everything ready to go on that, and adding the additional case with the additional issues, it would have made it even more unwieldy in that case. And again, as Mr. McCormick has stated, the difference here is now that we do have an issue on the standby pay claim and how this commission ruled on the standby pay claim. The standby pay claim was just one issue in Mr. Heckman's appeal.
Any other questions?
Yeah, so this might be my lack of legal expertise creeping in, but so let's say that a stay is granted. What happens next?
So if a stay is granted, basically what that means is that this case is put on hold and we wait until the Court of Appeals reaches its decision. And then I guess it's possible there could be an appeal to the Supreme Court, North Carolina Supreme Court. So we would wait until the appellate process is finished, and then we would come back and pick up this case after that time, if a stay's entered.
I see. Okay. Thank you.
Yep.
All right, unless there are other questions, we can move to discussing as commissioners the views of the commissioners on the motion to dismiss and the alternative to stay.
I'll go ahead and go first and give my thoughts. As I mentioned earlier, we are often faced with cases where the city files a motion to dismiss, and I'm sympathetic to the employees, because a lot of times it's a technicality in which we have to dismiss. They didn't follow the proper appeals procedure, or they're seeking equity. Because this is not a board of equity, it's a board of limited jurisdiction. And so, and so those cases for me are more clear cut, whether I agree the employee was wronged or not. We are limited by what we can hear and what we can decide. The city, in my opinion, has presented some compelling arguments in why various elements of this claim of this petition should be dismissed, and then the petitioners the petitioner has come back with their own questions and their own doubts to those claims, and so for me this isn't a clear-cut motion to dismiss. And, for lack of jurisdiction or statute of limitations, I think the fact that, this has gone on for, an hour and a half lends itself to there are complexities. And I would not feel comfortable dismissing this because I do think the petitioner has a right to hear the evidence heard and to hear, the responses to the city's claims and the city's responses to the petitioner's claims, and so there's enough gray area in here that I think we do have jurisdiction to hear this case. And it may be that we get into an evidentiary hearing and the city provides the same motions halfway through the evidentiary hearing or towards the end of that. And after seeing the evidence, I may agree with the city and realize that the city is on the right track here. But I just feel like I don't have enough information. The city hasn't been compelling enough to for me to feel comfortable dismissing this case without hearing the facts of the matter, because the petitioner has been on the right track with addressing the city's claims. So those are kind of my thoughts.
And just to follow that up, I do want to say, these are two separate issues, right? We have the issue about the allegation about a possible demotion, and also about back pay or standby pay. In terms of the allegation about a demotion, I think that we have enough to go off of, especially in the Civil Service Act, where I believe we have the authority to sort of look into this matter in a more in-depth lens and sort of figure out whether this was indeed a lateral transfer or a demotion. But in terms of the standby pay, I personally believe that since the 15-day statute of limitations passed, it kind of it's hard to say, but just striking this down on the technicality, pains me. But in terms of that statute of limitations, I think that ultimately there should be a stay on this case, on that matter, mainly due to the fact that a similar case is being heard by an appellate court. But when the time comes, I'd like to make the motion to grant or reject the city's motion to dismiss the matter of the allegation on the motion, and make a motion to grant a stay for the standby pay matter. Thank you.
Well, and I was early on. I was kind of where you are in terms of agreeing that maybe we should grant a stay. But then the petitioner made claims that this is different than the first case, and there are different elements and different things that make this a different case than the first. And so I think in my opinion, we may get to a place to where we say, okay, we have to issue a stay on this until that other one's decided. But then the burden's on the petitioner to prove how it is different and how it is a different case and stuff like that. And I think you can only do that through an evidentiary hearing. And so that's kind of why I was like, I would want to hear evidence on both of them, and we may end up getting to, a stay or a dismissal one or both of the claims. But I think having evidence, because both sides presented very compelling arguments on why it's different, and the fact that it's not a clear-cut answer for me is why I would want to hear evidence on both of the issues.
Right, and I agree with that. Personally, I see it as, it would be better to proceed with an evidentiary hearing with all of everything else being resolved, right? So perhaps we can proceed to an evidentiary hearing and then decide that, you know what, maybe we want to change our minds and sort of wait it out until, the other case is decided. But I think it's better to be safe than sorry and just sort of wait it out first and sort of see where this other case leads and then come back and just hear it out.
Yeah, and I think we have the petitioner's not making the claim that it is the same, and so I think we have a duty to the petitioner to hear an evidentiary hearing, because they are claiming that it is different, and give them an expedient hearing, because he has been waiting a long time for this because of COVID and the backlog and stuff like that. And so we may end up getting there, but I think they're claiming that it is a different case with different facts and different circumstances, and that's their burden to prove it. And so that's why I would be in favor of rejecting the city's motion to dismiss and the city's motion for stay at this point without prejudice, I guess is the right term, maybe.
Other discussion?
Can we put the city policy, the definition of transfer back up? You have this on a slide.
And I actually have copies if you would like
No,
to.
if you can just put it back on the.
It might take me a moment to get there. Of demotion, right?
What constitutes a transfer? You had a slide
Okay.
under the policy.
Okay, so here's the definition under policy 300-1A of a lateral transfer.
Okay. And so the language there, and you highlighted it, the same class title and or pay grade. And I think that this is not technically an evidentiary hearing, but I think in the record here, it's clear that the sergeant was in the same class title and pay grade. So that's my concern here. I don't see what other evidence you would have to show that something was different. This language here doesn't seem to contemplate, the value of an allowance versus free uniforms, or it doesn't seem to contemplate the use of a city-provided car. So I'm just trying to get in a little bit more into the actual definition of what a transfer is under the city policy, since we've got to have a violation of that policy.
Would you mind putting back up the demotion definition?
Yes, ma'am. And again, I have copies if y'all want to see copies of those definitions, but here it is on the screen.
So, I'm sorry, I didn't hear that.
Oh, I was just saying, we've been going about an hour and a half, and
Yeah.
so I don't know how much longer this is going to be
Yeah.
going, but I am going to need a break.
Okay, we'll move forward. Are there other comments? Commissioner Holland, did you have any comments or questions?
My current thinking is on the demotion issue. I would be in favor of granting the city's motion. I do not think that a change in some incidental benefits, if you will, falls into these definitions that we've been looking at as to a lateral transfer and a demotion, and I don't think a hearing would change my mind on that. With regard to the statute of limitations, I generally think that the 15-day statute applies and was not followed here. So I would be in favor of granting the city's motion on that as well.
Well, I mean, I think the petitioner argued that at a minimum, there's 15 days worth of violation that could be included, correct? So he would be at minimum, because the city's not arguing that he didn't follow the grievance procedure for the effect of the demotion, right? What the petitioner claims as a demotion. So then the petitioner at a minimum said, well, he's at least minimally entitled to 3 weeks or whatever that time, whatever we get a calendar out and figure that time frame with holidays and weekends and stuff like that. So at a minimum, he would be entitled to at least 15 days if we follow that grievance period, correct?
No, I don't think it's, well, I'll.
Because if he made if the violations have been going on for 5 years and he made the petition he made the complaint on January 1st, then he at least has 15 working days of grievance that do fall within that grievance window. Even though it had been taking place long before that, he at least has 15 days that could be considered. What's the city's position on that?
The city's position is that the statute of limitations would have started running April 11, 2018, when the new memo came out, or it could have started running when he was assigned to fugitive in June of 2018, or when he was assigned to TARO in December of 2019, and he was assigned standby duty and did not get the pay. And because he didn't file his grievance within 15 days of any of those, then his grievance is barred.
Yeah, and I think the petitioner's argument for that is that up until that point when he said, hey, my guys aren't coming in, and then his superiors got very angry with him, allegedly got very angry and frustrated with him, that's when he realized that, oh, maybe this isn't voluntary. Maybe this is I'm on standby pay or I'm on standby duty and not getting standby pay. And so I think that's what he's arguing, is that up until that point, he did think that it wasn't mandatory and that it's like, hey, can you come in? No. Okay, no big deal. But he's alleging that on that date, it was made very clear to him that it wasn't optional and that there could be possible retaliation, possible violations of city policy, et cetera, et cetera. So at a minimum, I think there's at least a 15-day window. Even if you agree with the statute of limitations, I think it's a very compelling argument that it was at that time when he realized that this isn't optional. And then the other argument of he wasn't in a standby. I believe the petitioner made the claim that he wasn't in a standby pay position when that memo came out, and that's also for me a compelling argument because he's been in the police department for 20 years, and so if a memo was issued 19 years ago when he was an entry-level sergeant addressing these issues, are we to assume that that is effective notice for something that happens 20 years later in his career? I don't know. That's a question.
He also admits in his grievance appeal as well that in September of 2019, he was aware that his Lieutenant Godwin had requested standby pay for folks on his unit, so the statute could have started running there. In any event, he missed his 15-day grievance window.
So I think we need to go ahead and call the question. Oh, did you have one more question?
I have a suggestion. I tend to agree with Ms. Holland on this issue, but I believe our rules require 4 votes either way to do this. It appears to me there are not 4 votes here to grant the motion to dismiss. So I would like to go on record. I'll just make a motion to grant it, and then if it fails, then we can move
Grant
on.
the motion to?
Dismiss.
Okay, so as I understand the rules say that we need 4 votes to reverse or modify the city's decision.
Well, that's what I thought too, but it says, or any other decisions by the commission shall require 4.
Guys, I really need you to please speak into the microphones. I'm having a really hard time hearing you.
Okay.
Sorry.
Or any other decision, I see down there.
Or any other decisions. And frankly,
Okay.
I had forgotten that myself, actually.
Yeah, okay. So let me call for a motion, if I could.
I will move that we grant the city's motion.
I have one clarifying question on.
I didn't hear what he said about his motion.
He said he wanted to move to grant the city's motion, both to dismiss or to dismiss.
Yes.
Is the motion one motion for both items, or is it a separate motion for each item?
Well, if you granted the motion to dismiss, then there's only one item.
Okay. So if we grant the city's motion to dismiss, we're wiping out the whole case, and then so we can, if we disagree with that, then the city could come back potentially and file a motion to dismiss part of the claim. Is that correct?
Well, they could do that, but and that would be up to the city.
Sure. Okay.
So there is on the floor a motion to approve, to grant the city's motion to dismiss. And I guess we can, I don't know that we need a second, but is there a second?
Second.
Okay. And so let's have a vote on whether or not the commission will approve the motion to dismiss. All in favor of the motion, please indicate by saying aye. Aye. Any opposed?
No.
And so because we do, for any decision, require an affirmative vote, the city's motion is denied. So let's take a break.
Chairman Klein, if I
Yes.
may, if you look at the 1989 revisions to the Civil Service Act, it just says any modification or reversal of an administrative officer's decision or reversal of an administrative officer's decision or any other decision by the commission shall require 4 affirmative votes. So,
And
Cannot hear you at all.
she objects to any further argument. And Ms. Smith, I think what we're talking about here, just to be clear, is Mr. McCormick pointed out that language or any other decision.
that's correct. And I was thinking that there was somewhere else in the Civil Service Act where it said that a majority of the folks present could rule.
And I'm objecting to further argument.
And Ms. Stevens is objecting to further argument. So I think where we are standing is that the city's motion to dismiss has failed. And so we'll set this up for further hearing. Now, let's take a break, and we need to move to the next matter, which is the Jeffries matter. And I know that there was some, Mr. Pacini, some things we needed to set up in terms of receiving the witnesses.
Yes, the respondent and the appellant taking their places, of course, the witness will be where they are now, so.
So let's take about a 15-minute break.
And I can take those notebooks back if you don't want to keep them.
Salute.
The Civil Service Commission is back in session, and we are now going to take up the matter of Tony M. Jeffries' appeal for the city, and I'll have the parties introduce themselves. Mr. Jeffries, if you will make sure for the court reporter that you speak very clearly and into the mic.
Okay, my name is Tony Jeffries. I'm representing myself. I don't have an attorney in this matter.
Okay. And for the city?
My name's Isaac Ridgway. My name's Isaac Ridgway. I'm representing the city of Raleigh in this matter.
All right. And just as a housekeeping matter, we will we'll first have opening statements from the parties, and then Mr. Jeffries, it'll be your obligation to put on the evidence that you have, and then the city can put on its evidence in a prior agreement among the parties and in consultation with me. You've asked to have a witness appear by Zoom.
Yes.
And the city's consented to that, and that's what we're going to do after, when it's time, when you want to call this
Okay.
witness, he'll be ready to be called. But at this time, it's time for the opening statements, and we'll start with you.
Okay, thank you, Chairman Klein. I have a written statement I want to read too. It says, "Good morning to everyone, and thank you so much for the opportunity for allowing me to speak on my behalf in reference to this matter of the wrongful termination. That I feel that was a wrongful termination. Today, I would like to present information and evidence to why I feel I have been targeted wrongfully and wrongfully terminated. Before I present any information to this claim, I would like to give some background information concerning who I am and my history with the city of Raleigh. My name is Tony Jeffries, and I started my career with the city of Raleigh in 2005 as an EO2 driver in the recycling division, which in my opinion was a great accomplishment, and I was so proud to be able to represent the city through the opportunity that I had been afforded with the recycling program, because I was so passionate and demonstrated great pride in my work. I was able to advance from that position after only being in that position for 2 years. After 2 years, I was asked by the operations superintendent, Larry Searles, to transition off of the truck as a driver and to lead a division in the recycling section. I accepted this position with no hesitation because I felt Mr. Searles saw something in me that could help the department progress further. After my 3rd year with the city, a supervisor position became available, so I decided to apply. After going through the hiring process, I was awarded the position of supervisor. It was an honor to serve in that capacity. As my career progressed, I always was looking for ways that I could help the department to achieve its goal of supporting other departments within the city to become more efficient and taking care of the citizens within the city of Raleigh. I not only did my job, I took it upon myself to learn about every piece of equipment, machinery that solid waste had. In this case, we had shortages, so that's why I felt that I needed to step up and help out in any way that I could. In one instance, I was asked during a bad storm to go to New Bern, North Carolina, to operate a boom truck to assist in the debris removal and cleanup. I spent over a week there to help that community come back to somewhat normal. I also had the opportunity to represent the city of Raleigh in a national organization competition called SWANA, Solid Waste Association of North America. The competition is where drivers from across the country come together to showcase their driving skills using various solid waste equipment. While competing within this competition, I have won first place twice. As well, I took 2nd and 3rd place out of a numerous skilled drivers that were from across the country. I took so much pride in the fact that I was representing the city of Raleigh. I was able to bring several trophies home, which gave me a sense of accomplishment for a company that I felt so much passion towards. I worked extremely hard to gain the knowledge and the skill set and experience I have to make sure I always exemplified excellence on my job. That is why this situation of being terminated has placed me in a mindset of shock, disbelief, and major concern to why I have been wrongfully dismissed from my career I love and respected for over 15 and a half years. First and foremost, I want to address the overwhelming amount of disciplinary actions that are being presented in this attempt to attack my character. My knowledge of policy and procedure and my many abilities and skill set to do my job with a professional and excellence, if proper procedures and policy were followed according to the progressive discipline, I would not be at this point of termination. We must take a close look at the steps that were taken against me that ultimately caused my dismissal from the city of Raleigh. It is my belief that I have been targeted and made to feel that my thoughts and opinions did not matter and that my voice of concern and truth meant nothing. The reason I felt this way is because although I followed proper protocol and presented my concerns to my immediate supervisors, they were overridden, deemed not credible, and dismissed, not even considered. I was not even advised of an appeals process in one case following a specific incident. I have always maintained the stance that after every incident that happened with me, according to the policy and procedure, I always followed them and professionally, and properly and professionally. But my efforts and actions were ignored, belittled, and dismissed, and replaced with personal agendas. I must say, I truly feel I have been targeted and singled out because of the way I carry myself while working on the job. I am not one that can see wrong being done to someone and not speak up, respectfully bringing awareness to the wrongful deed that was being committed. I would do that for anyone. I feel that I feel what makes a great leader and a team player when you are willing to put yourself at risk for the betterment of others and the reputation of the company. As a supervisor, according to the Department of City Policy, when administering disciplinary action.
Sir, I need you were doing great and then you just really started going fast.
Okay, I'm sorry.
Thank you.
Okay. As a supervisor, according to the departmental and city policy, when administering disciplinary action on an employee, whether it is disciplinary action or a formal evaluation, the supervisor can only consider what the employee violated during their annual review, the previous annual review, to what occurred on, and as a safety, like an accident or something like that, dealing with safety, the department is allowed to go back 24 months. In my case, all the disciplinary action taken against me should not be considered based on the above-mentioned policy. This is considered prejudice against me. In my statement, I want to reiterate the occurrence that took place that led up to the progressive, unwarranted act of my termination at the time of the accident. Policy and protocol is clear and immediate following an accident or incident that you are to call your immediate supervisor ASAP, as well as a police officer has to be called if one is required at the time. On this day of the accident, that's why I have Mr. Davis on the conference call to testify to this. Mr. Davis, my immediate supervisor, and safety officer Abe Jones were called to the scene, in which both came and a report was made. In the interim of it all, after hearing of this accident, Mr. Stan Joseph came to his own conclusion that I was trying to flee the scene of the accident and basically encouraged actions that was taken against me to propel forward without regard to what really happened on that day.
Madam Chairperson, may May I object? I thought this was opening statement, so I didn't want to object during it. But the contents of what he's talking about right now is outside the subject matter of this hearing today. Although it's a cumulative discipline case, and this is a former discipline action, the thing that he is talking about, the incident that he is referring to, happened in 2019. He followed an appeals process throughout it that did not land itself to the Civil Service Commission. He did not appeal it this far, and it is outside the scope of what is being heard today.
And I also said,
Hold on just one moment, and I'm gonna allow him to continue, and you can certainly raise your concerns about this in your statement.
Thank you.
Go ahead, Mr. Jeffries.
thank you, Ms. Klein. Mr. Davis, my immediate supervisor, and safety officer Abe Jones were called to the scene, to which both came and did a report. This action was taken against me, was discussed between safety officer Abe Jones and my immediate supervisor, James Davis. I just said that. Respectfully, if Mr. Davis and Mr. Abe Jones' report and suggestion was considered in reference to this unfortunate incident, I feel strongly that I would not be at this level of disciplinary action, which resulted in me being terminated from my position that I have worked tremendously hard to uphold the standards and work ethics within the city of Raleigh for 15 and a half years. Lastly, I would like to speak on another incident. Well, I won't do that. I'll do that in my testimony through the witnesses. So that's what this one is about. I'm actually waiting for this witness because he's working today, and he said he didn't have anyone to cover his route. So he's trying to get here now, so I don't know if that's going to happen. I think Mr. Joseph could speak to that to probably get him here.
Okay, so we'll need to, if you will want to finish your opening statement. Now, at this point, you have not been sworn in, and so you're not testifying. This
Right.
is just your summary of what your case
Okay.
is. So
Okay.
if you want to complete that, then
I
the
will.
city will have their opportunity.
I will. Thank you. Let's see. The one I wanted to talk about is Mr. Moore was a front-end loader equipment driver. He drives the truck that service dumpsters of recycling material. I volunteered because of such shortage that was within the department, because even today, like, he can't get here. I volunteered to help him out so he could take vacation, or wherever there was a shortage, I was able to help him out. So I volunteered to be trained on this truck to help the department. On this particular day, which I was actually disciplined and demoted to a driver from a crew leader position, and I wasn't even involved in driving the vehicle. I was a passenger being trained by Mr. Moore. What happened was the truck dropped a dumpster inside the vehicle. We took it back to the office. Mr. Moore had the dumpster removed. And like I said, I was being trained by him. Had never worked on this vehicle, this type of vehicle before. So he was a trainer and I was the trainee in this position. So I didn't know any safety features, wrongs or right with this particular vehicle. I was learning how to operate this vehicle. Mr. Moore chose to, after they retrieved the dumpster from the vehicle, Mr. Moore decided to lift the dumpster up and take it back to the downtown where it fell in the truck. Another supervisor saw Mr. Moore driving the vehicle with the dumpster on the front of the truck, and so our superintendent called and said, return that back to the office. So while he was trying to maneuver the truck to take back to the office, Mr. Moore hit the back of another car. He did that as a trainer. So having the box on the front of the truck, hindsight said, yes, it was unsafe, but I didn't know that because I was being trained on the truck. Superintendent Griffin Hatchell chose to hold me accountable for the accident, which I did file a grievance on, which It went to one step, it went to stand, and Mr. Joseph decided to uphold that infraction against me and demote me when I was being trained on the equipment to help the department. So I was like, that was part of the progressive discipline that was also added up in order to come to this termination. So that's why I was using that. I just wanted to say, I just wanted to be heard, and I wanted the actions to be reversed, because I feel that I did nothing wrong. I did all I could for 15 and a half years for the city of Raleigh, and the action that was taken, pretty much I feel that was against my supervisor's recommendations, and it was encouraged by upper administration to go ahead and proceed with the actions. So that's why.
Thank you very much. I'll hear the city's opening statement now.
Good morning, or potentially afternoon. May it please the commission, my name is Isaac Ridgway, and I'm appearing this morning on behalf of the city of Raleigh. The city's position is that Mr. Jeffries was properly terminated as the result of a cumulative progressive discipline case, which I will be going in more detail in my case in chief. The city does not believe that Mr. Jeffries can show by the greater weight of the evidence that the city violated any of its policies related to his termination therefrom, nor can Mr. Jeffries separately show that his termination was unjustified. One of the main events that we will be discussing today is a car accident involving a city-owned trash truck that Mr. Jeffries was operating when he backed the truck into a resident-owned vehicle in a cul-de-sac on December 15th, 2020. Although Mr. Jeffries' ultimate termination from employment was in some ways triggered by the incident on 12/15/2020, it's important to emphasize that that incident was not by itself the reason that Mr. Jeffries was terminated. He was terminated as the result of a cumulative pattern of misconduct that collectively gave rise to his termination. Similarly, Mr. Jeffries has utilized his appellate processes throughout his career. Although this is, I believe, the first time that he's appeared before the Civil Service Commission, there are multiple times where he has appealed up to his supervisors of various levels, up to Stan Joseph and even the assistant manager's office several times. So he understands the appeals process and the way that that works within the city. The reason that I say that is because based on his opening statement and what I anticipate by the witnesses being called, a lot of the content that he is going to try to talk about will revolve around those former disciplinary actions that are not properly before the commission today. Although those decisions are very important to the ultimate decision of him being terminated, the facts thereunder are binding because he did not properly appeal them. Furthermore, we went through the content that he did not appeal in our pre-hearing conference order, and we stipulated to the fact that that's what these documents say. During my case in chief, I will introduce evidence about Mr. Jeffries' history with the city, introduce evidence surrounding this 12/15/2020 incident, walk the commission through the appellate processes and the investigations therefrom that have occurred to get us where we are today, including calling witnesses from the city's supervisory staff who work directly on this case. Thank you for your time.
Thank you. Mr. Jeffries, you are now going to be sworn in by the court reporter, and then you can either testify yourself or call your first witness.
Okay.
Are you going to testify first?
The one that's on the Zoom call, that's my immediate
that's your
supervisor,
first witness?
Mr.
Okay.
Davis.
And is
yes.
that Mr. Davis?
Yes.
So are we ready to pull Mr. Davis into the hearing?
Stand by. for that.
It looks like Mr. Davis is still muted. Is that what we're working on? Oh, now we are.
Thank you so much.
Can you hear me now?
Yes.
Mr. Davis, good morning. Welcome to the Civil Service Commission. I think Mr. Jeffries is now going to call you as his first witness, but first you'll need to be sworn by the court reporter.
Okay.
Mr. Davis, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
The witness is yours, Mr. Jeffries.
Do I need to be sworn in?
No, you're now acting in the, and you're basically asking the questions of your witness, and when you
Okay.
testify, you'll need to be sworn. So you
Okay.
can start asking questions of Mr. Davis.
Okay. Good morning, Mr. Davis.
Good morning.
First of all, I was like, state your name and the position you held with the city.
James Davis, and that position was operations supervisor.
Okay. The reason why I brought you in as a witness is to testify to the incident of the accident that led to the progressive discipline of termination.
The city objects.
Can you speak to?
One moment, Mr. Jeffries.
So the city objects because, as mentioned earlier, the incident that he's referring to happened in 2019. It was not appealed up to the Civil Service Commission. This witness, although he was his supervisor during a cumulative discipline time period and could testify to Mr. Jeffries' employment generally during that tenure, I don't think that it is appropriate for him to testify to that specific incident because the facts thereunder are not in dispute before the commission today. Furthermore, Mr. Davis was not the supervisor at the time of the 12/15/2020 incident. In fact, he resigned almost a year before. So he would have no knowledge of the stemming, of one of the stemming underlying issues before the commission today.
So, Mr. Jeffries, do you want to respond to that? I think what
I do.
Yeah, what the city is saying is you're here before us on a
I
particular
understand.
incident, and it sounds like, according to the city, Mr. Davis was not involved in that incident,
Right.
but was involved in a previous incident, which was, is it correct to say, not appealed? Or
It was appealed, but it was not appealed before the Civil Service Commission. So it was appealed within the city's internal departmental policies where it reached an end and was not further appealed either outside or inside the time limits.
And I can speak on that.
Okay.
And the reason why that it wasn't appealed because no information was given to me about that. That was one of the first appeals that I had filed with the department. Before, when I have incidents and stuff, it stayed local within the department, so I filed there. So after Mr. Joseph came back and said he upheld that standing, I was never given any information that I could appeal to the civil service.
So, Mr. Jeffries, help us understand why Mr. Davis's testimony is important with regard to
Okay.
this incident.
The reason why is because that incident was that led up into this position for the termination, because they went back and pulled that incident to hold me accountable to be terminated. So that's why I wanted to appeal, or I wanted that to be on the record as saying the reason why I was being terminated was due to that accident where Mr. Davis was my supervisor.
Okay. So I'm going to allow a very small amount of this. I mean, I don't want to go into a lot of detail because I think the city has a point, and I'm going to allow the evidence in just for the purpose of illustrating what you're talking about.
I understand.
But I cannot promise that it will. The city may make other arguments about whether this or is not relevant.
Right.
But I'll allow a limited show of what
Okay.
you think Mr. Davis can contribute to this case.
I understand. And I thank you for that. Mr. Davis, I don't want to hold the board up too much time. Can you speak on some of your duties that you did as a supervisor And how long did you work for the solid waste services?
That was 2019, so give me a second. I know it was the recycling department, which included front-end loaders, side loaders, and rear load vehicles, time cards, and disciplinary action and evaluations.
Okay, that was my next question. When you, as the supervisor, approximately how many employees did you supervise?
I believe that was a little over 30 or 40.
Okay. You did mention that you did their evals annually, right? While you was there.
Correct.
When you did the evals, when you pulled a employee's record, how far were you able to go back in order to determine their standing on that evaluation?
That I don't recall.
Okay. Did you go, would you say that you went back more than 2 years or 3 years?
No.
Okay.
You're asking for their current year's evaluation?
Yes.
Yeah, no.
Okay. For a safety violation, you're able to go back 24 months to consider for any disciplinary actions, correct?
Again, that was 2019. I would agree with that from what I think I remember.
Okay. On the day in question, the accident that's being used to determine termination, there was an accident where I was driving a city pickup truck, and I backed into a handrail. I called you right after that accident, did I not?
That is correct.
And that is...
Chairperson, we object again. This is, again, detailing into a former disciplinary matter. This one actually even further back. That was not appealed before this commission. I don't want to continue to interrupt Mr. Jeffries' testimony.
It's the same accident. It's the same one. It's not a different one.
So Mr. Jeffries, we can't relitigate.
Right. I understand. I didn't
talk.
One at a time, please.
Yeah. We can't relitigate these prior cases. If there is something pertinent to this particular case that we're here about today, because the city has not brought forth any of their witnesses for those prior cases, we can't relitigate that.
I understand.
And so if Mr. Davis has any pertinent testimony about why in this particular case, we just can't go back through the details.
All right, I understand. I just wanted to ask some questions that's
Just one
related.
moment.
I'm sorry, guys. I can only take down one person at a time. Sir, I really need you to please wait until they're completely finished speaking.
I understand.
Otherwise, I'm not going to get your words on the record, and I know you want your words on the record.
Yes, and I apologize.
To clarify for the record, there is a front-end loader incident that occurred in 2019. That was one of the incidences that he was referring to earlier. This one that he's referring to now, involving a Taco Bell, was a separate incident. Mr. Davis, I believe, was his supervisor at the time, but I just want the record to reflect that there were multiple instances.
And just so, because we are getting all of this sort of, all at once, is it the city's position that those two incidents, the Taco Bell incident and the 2019 incident, were used in evaluating whether, as part of the progressive discipline in this case?
Yes, his entire disciplinary history, with a particular emphasis from 2018 to 2020, are ultimately, I will let my witnesses testify to what the ultimate determining factors were, but yes, our position is that it is a progressive cumulative discipline case where his former discipline was considered.
And so having said that, Mr. Jeffries, as I said, we can't relitigate those prior
Right.
incidents. If you have questions about other questions from Mr. Davis that are pertinent to this case, you can go forward and ask him.
Okay. What I wanted to say is that he said he was going back to 2019. According to policy, you can't go back
Okay, so now, but you can't testify until you're sworn. You can ask Mr. Davis questions.
Okay.
And then when Mr. Davis is finished, we'll have you sworn and you can testify about whatever
Okay,
you think
all
is,
right.
is pertinent. Okay?
Okay, understand. Mr. Davis, as a supervisor, do you feel that you had free reign to run your division as you saw fit?
Correct.
Okay. Did you have any outside persuasion, suggestions, coercion in order for you to do your job?
No.
Okay. Okay, so all decisions that you made as a supervisor, you made it without consultation with upper administration?
I consulted a lot in that 19 2019 year, as I was new to the city of Raleigh. So I think you were aware a lot of policy was new to me. So I consulted a lot with leadership and peers.
Okay. So, but the ultimate decision for discipline, did that mainly fall on you, or did you have consultation about that?
Yeah, all discipline we had consultations about at that point.
Okay, and the ultimate decision was yours to administer?
Yeah, it was combined effort or solely ours.
Okay, you said combined effort.
Correct. And what I mean by combined is me being newer to the city, all policies weren't, the strong suit at the junction, so we wanted to make sure all policy was being abided by. And so to get that information, you had to ask resources that were more knowledgeable than yourself in terms of aid and interpretation of that.
Okay. Do you feel, and I know I can't relitigate that incident, do you feel that when I did have something to happen, a violation of something, do you feel that I did follow protocol and procedure?
Hold on one second. Can you hear me now?
Yeah.
Yes.
Can you hear me?
Yes.
Yes.
Can you hear us?
Okay. Yes.
Okay.
Did you hear the question, Mr. Davis?
Could you repeat the question?
I said, did you feel, while you supervised me, if I had a violation of something, do you feel that I followed proper protocol and procedure?
While I supervised you, followed proper protocol and procedure. Yes.
Okay.
And I believe that was written in from that 2019 write-up, or what took place or what did not.
Okay. Okay, that's all I have for this.
Does the city have questions for Mr. Davis?
Mr. Davis, Mr. Jeffries asked you if you felt that during his employment, when you were his supervisor, if he was following proper procedures, and you said yes. Is that correct?
Yes, and speaking of terms of if he called when that accident happened is where my mind was thinking and other things. Correct.
Would you include driving away from the scene of an accident as proper procedures?
No.
No further questions.
Can I have a rebuttal on that?
You may.
Do you feel that I was fleeing the scene of an accident?
With the information we had at that time, and if everybody doesn't mind me going into that, I'd like to paint the clear picture of that. We received a phone call that from Mr. Jeffries that he was involved in an accident, went on site, did our regular reporting, Me and as well as the safety supervisor at the time. We then received information from, I believe it was the on-site manager at Taco Bell, that it was his belief that there was an attempt made by Mr. Jeffries to flee the property and that he would not have stopped if he would not have stopped him. From what I recall from that, because we had video as well, if I remember, you pulled out of a spot and went to another location in the parking lot, which we saw where the call was made. But you can see the manager in that video comes up to your vehicle as you're backing away. I believe in your statement you said you were trying to get away from traffic flow or whatever was occurring in that area, construction that was blocked off one way, and me and the safety supervisor went back to see that, and that gentleman stated that he would write a statement. So from our belief at that time, what we could see, we knew the call was made in 2 or 3 minutes from, or less than the accident took place. So it appeared that you followed the procedure in terms of notifying us of an accident, but it was the interpretation from the matters of that scene of how it appeared to be. That from that gentleman, another leadership person of that organization, stating what he saw and took place in his belief. I don't recall if that statement was ever provided or not, but I do remember. That's what I remember from 2019.
You have anything further?
You said you don't recall that manager ever writing a statement.
I remember myself reaching out as well as Abe Jones. I got nothing back in terms of him providing the written statement. I do remember receiving the video, but not the written statement.
And I would go ahead and object to any further testimony on this specific incident.
I'm going to sustain that objection.
Thank you.
Anything further from Mr. Davis?
No, it's not, no.
Anything further for the city?
No.
Thank you, Mr. Davis. I appreciate your cooperation and testimony today, and unless there's anything further from you, I think you can go back to what you're doing.
Thank you.
Mr. Jeffries, do you have another other witness before you
I do.
testify?
I
Okay.
do.
So let's talk for just a minute. It's almost noon. How long do you think the second witness will take?
Not that long. He's here.
Okay.
He's a crew leader with Solid Waste Services, and it's less than 10 questions,
Okay. All right. And again, I'm going to caution you that we are interested today not in relitigating past incidents, but
Right.
in what we have before us based on your termination.
I understand. This won't be anything dealing with an accident. It's just policy and procedures.
Okay. All right. Do you want to call this witness?
Yes, Maurice Leach.
Sorry, I didn't catch. What was that witness?
Maurice Leach.
Mr. Leach, I think we need you right here, if you could.
Come around here.
And sit, yeah, sit right there. And you'll first be sworn, if it's okay. And state your full name for the record first.
Maurice Clifford Leach.
Okay.
Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may
Okay.
go ahead and question this witness.
Okay. Like I said before, state your name and your position that you hold with the city.
My name is Maurice Clifford Leach. I'm crew leader for the city.
Sir, I need you to speak up, please.
My name is Maurice Clifford Leach. I'm a crew leader for the city of Raleigh.
How long have you worked for the in that position?
I've been crew leader for 16 years. Well, not, excuse me, for probably
Approximately.
13 years.
What are some of your duties that you do as a crew leader?
Oversee crew, make sure the crew out goes well, answer any complaints that customers may have. Just make sure that everything goes well.
Speaking to the mic.
Yeah, I'm sorry.
Stay in the
Yeah,
mic.
just to make sure everything just goes well.
Okay. As a crew leader, was it part of your duties to train new and temp employees on how to work on equipment at Solid Waste Services in a safe manner?
Yes, it was.
Okay. As part of that training, did you train them on how to back a vehicle using universal signals?
Yes.
As we both came into solid waste as solid waste drivers, we had this same training by our supervisors and safety officers, correct?
Yes, as far as I know, we did, yes.
As a driver, when you drove a truck, or even when you drive your truck now, depends on which vehicle, we were trained on having a primary spotter, correct?
Yes.
We're trained on what?
As a rear-loaded equipment vehicle.
I just, when I ask for clarification, what I mean is I'm just asking for you to repeat the words, I just didn't hear them, that's all.
Primary spotter.
Primary responder?
Spotter.
Spotter, oh,
Yes.
thank you.
I'm sorry, I apologize. Let's see. Even though 2 service specialists are assigned to a vehicle, one is only used as a primary spotter, correct?
Yes, pretty much.
You
for
can't,
me as well.
okay, you as a driver is ultimately responsible for the vehicle, correct?
That's correct.
But we take great weight into who's spotting us when we're back in a truck, correct?
That's correct.
When we go into an area that we may have to maneuver the truck around, we assess that area where we have to service, correct?
Yes.
Including getting out and look.
Yes.
Okay. While back in a truck, we were also trained never to lose sight of your primary spotter.
That's correct.
And if you lost sight of your spotter, you were to immediately stop the vehicle
That's correct.
to regain sight.
Yes.
Just one quick question. Have you, in your position, ever assisted a supervisor into doing evals?
No, not a sit. Well, if they had a question to ask about a particular employee, you know, what did I observe or how was he, I may give an opinion every now and then, but not often.
Okay, but when you did, that was what was considered is what that employee did for that previous year?
Yes.
Okay. You attended the Swana Rodeo several times with me, right?
That's correct.
In that Swana Rodeo, Solid Waste Association of North America, drivers from across the country came together to test their knowledge and skills on equipment, correct?
Yes.
So you would say when you made it to the nationals, you were, not just you, but the guys that were there were considered best of the best.
Yes.
As far as, and if you brought a trophy, you were one of the top notch.
Yes.
As far as knowledge and skills of those vehicles.
Yes.
Okay. That's all I have for this witness.
Okay.
Thank you,
Do
Mr.
you have
Leach.
questions for this witness?
Yes. If you could give me just one moment, please. Mr. Leach, can you hear me? Everyone good? Mr. Leach, you said that at some point you were trained with the notion of the primary spotter, and that in situations where there could be two spotters available, there may be situations where you opt just to use one?
Well, when I was trained, I only used one, and that was basically the one that you really trusted the most.
What would you do? What would you do with the secondary spotter or person if you would not
secondary
use
person? I would make sure he was in my vision, but I only used my left spotter on the driver's side because that was my strongest guy. And if I had any doubt or inclination, I always stopped the truck and looked myself.
So even if we were to assume a theory of a primary spotter, which the city will dispute later, you mentioned that you used the one on your driver's side.
Yes.
Why would you use the one on your driver's side?
Well, because basically whenever I would enter a cul-de-sac, I've already took an overlay and looked at everything I need to see. And I would basically keep him on my left side because that's which way I would normally look. And everything else over there, I know if I'm too close over here, then I'm going to hit something over there. So I know how to pretty much judge my...
Would you say that if you had one spotter to use, not a situation with two spotters, but one spotter to use,
Yes.
and you assessed a scene where there was a car, if you were backing up, that would have been on your driver's side, would you ask your spotter to be on the passenger side or on the driver's side?
Well, that depends on that person, whichever side, he felt was the most dangerous or wherever his power guy was. Like I said, I kept mine on my left side. That's the side of the truck he worked, and he was the one I basically trusted.
Would you say that somebody who has two spotters available to them on each side of the truck within clear vision, but chooses to use a passenger side spotter as opposed to a driver's side spotter, ultimately backing the truck into a car that is on the driver's side, would have been negligent in his duties by not utilizing both spotters and or making the decision to use the passenger side spotter as the primary spotter as opposed to the one on the driver's side?
But no, like I say, not necessarily. It all depends on how the truck or what's going on. It could have been something else in the way. As far as when it comes down to spotters, sometimes they might not be paying attention themselves. And like I say, myself, I chose to use one person all the time. And if it was two spotters, I made sure still my other guy was looking as well. And I looked myself.
Okay.
Can I ask one clarifying question real quick?
So let's wait until the city finishes, and then if the commission has other questions.
Okay, it's just a real simple question about which side the driver's on.
Go ahead.
Sorry.
Yeah, go ahead, Mr. Ridgway, and then then the commission can ask.
I think that I'll address your question in the case in chief.
No, I know, but just in testimony, it would help the commissioners if we knew if he was a left-hand driver or right-hand drive, because you're using driver's side and passenger side, not left side and right side of vehicle.
Okay. Let's see. When you mentioned that you went to the Swana rodeos with Mr. Jeffries, and
Yes.
So you're very familiar with Swana, I imagine.
Yes.
Okay. Are you aware of their best practices for backing?
Well, what they do do like everything else. You have to back a certain number of feet from a solid object, building. Well, they don't use a building, they use cones. And you back the closest to, basically you'd be looking at your left side. And you just back up, representing a wall would be a cone.
And so within the rules that SWANA has put out, as you understand them, and as Mr. Jeffries has said, maintaining visual contact with your spotter is an essential part of the spotting process, correct?
Yes.
And under SWANA, it also says that you should constantly be checking both your mirrors, your rear view mirrors, and the other safety resources that are available on the truck and at your disposal. Would you agree with that?
Yes, any good driver always, I drive by my mirrors.
So if you have resources available to you that could ultimately make your driving experience safer, and you fail to utilize one of those resources, ultimately leading to an accident, would you say that somebody may not be in alignment with the SWANA best practices?
Well, it goes like this. That's why I say I use one primary spotter, and I use my mirrors. When you're trying to keep eye on two people and still moving a truck, it can get difficult at times.
What would you do to combat that difficulty?
Me, like I said, I keep my eye on my main spotter, the one that I trust the most.
Would you be checking your mirrors as well?
I check my mirrors all the time.
Okay. Thank you. I think that's all the questions I have for him.
Can I?
Anything else?
Yes, I do.
The commissioner has a question.
Mr. Leach, you said that you, as a driver, choose to use the left side,
Yes,
the side that you're sitting on. That's your strong side.
that's my strong side.
Different drivers use different techniques in order when they're driving the truck, do they not?
That's correct.
Some may use the right side because that's their stronger side.
That's correct.
Some may use the left side because that's their stronger side.
Yes.
And as I stated before, when you go into a cul-de-sac, as a driver, you assess that area before you even start moving the truck.
Yes.
Your primary spotter, you said that's the one you go to because that's the one you trust the most.
That's correct.
So it doesn't matter which side that you spot from as long as you're using a strong spotter,
Yes, that's correct.
okay? In SWANA, during the SWANA rodeo, when you back a truck, there is no service specialist out there on that course, is it?
No, there isn't.
So that a spotter doesn't even come into play when you're in a competition.
No.
So whether you're driving, it doesn't matter which vehicle you're driving, whether you're driving an automated truck or a rear loader refuse truck, neither one uses a spotter.
That's correct.
Okay, so you're going mainly by your skills.
Yes.
So your head is constantly on a swivel looking at using your mirrors.
That's correct.
In SWANA, they do not allow you to use a camera, right?
No, they do not.
Okay, so you're backing a truck mainly on your mirrors.
Yes.
Okay. So that's all I have, for that.
Do the commissioners have questions for this witness?
I have one more question, if I'm allowed,
Okay,
for Sir
go ahead.
Rebuttal. There's a lot of language around spotters that you trust. What would you say is a distinguishing factor for a spotter that you trust?
As far as me, it's just somebody that knows the language, the signs. All of them are taught, but it's just like a kid. You may have one that get distracted,
Sure.
and basically, like I say, I mostly drive an auto, but I can drive any vehicle there, and I pretty much rely on my eyes, even though I do have a spotter.
So in these SWANA competitions, you do not have a spotter and you're not allowed to use a backup camera, correct?
That's correct.
And Mr. Jeffries, potentially through your knowledge as his friend or his coworker, has won several of these competitions, correct?
Yeah, that's correct.
And in these competitions, he was not allowed to use spotters or a backup camera?
No, sir.
Yet he was able to win competitions by avoiding objects.
Yes, sir.
Okay. Now, one of the reasons that you trust a spotter, I imagine, is because you know that you're ultimately responsible at the end of the day as the driver, correct?
That's correct.
Would you say that reliance on a spotter can be a useful tool? However, it should not be a crutch for a driver who otherwise independently has shown that he can navigate around objects on his own with limited safety resources?
That would be correct in my case. Now, as far as another driver, I couldn't really say. how comfortable they are.
Would you say that a driver who otherwise has shown a track record of being able to avoid objects in competition play without the use of spotters or without the use of a video camera would probably be benefited by having more resources, for example, having spotters or having a backup camera?
Well, no, if he's a good driver.
So a good driver may still use spotters, but understanding that because the truck is his responsibility, would take ownership and accountability of the process and do what they can within their own skills to navigate around objects.
Yes, like I say, every situation is different. You got to be able to judge and rely on me. I rely on my spotters and me. I don't depend on the cameras at all times either. I just rely on, my judgment.
So you rely on your judgment at the end of the day?
Yes.
Because that's who's responsible for the truck?
Yes, I'm responsible at all times.
Thank
for
you.
the men and for me.
And that's according to SWANA, CDLs, and City of Raleigh procedures as well, to your knowledge as a City of Raleigh supervisor?
Yes.
Okay, no more questions.
I just had one more. Going back to responsibilities, the vehicle, when you have a vehicle with a whole crew, even though the driver is ultimately responsible, everyone on that truck is responsible for the safety of that operation of that vehicle, right?
Yes.
Okay. That's all I have.
Any questions from the commissioner? Thank you, Mr. Leach. We appreciate very much your testimony. So you have how many more witnesses, Mr. Jeffries?
I don't see Michael Moore. He was the front end loader.
Okay.
I have Mr. Upchurch, which was my supervisor.
All right.
Mr. Upchurch and Cameron Hill, which was the spotter on the day in question.
I think what we probably should do at this point, we've been going since 9 with one brief break. Why don't we take about 45 minutes, if that's agreeable to everybody, to have a lunch break?
Is it possible? I know you probably have to he's at work. Okay. Is it possible we can get him in before the break?
If that's agreeable to the commissioners, we're okay with that?
Also, the city will be objecting to Michael Moore's testimony, so I don't know if that weighs into the consideration. I know that he has work, according to Mr. Jeffries, but just as far as calculus for the commission, he's from an earlier incident, and for the same reasons I've objected earlier, I would object to his testimony.
And I would like to use Mr. Moore because he goes directly to this hearing.
So is Mr. Moore the witness that you want to take now?
No, that's
Okay.
Mr.
All right.
Upchurch. Mr. Moore is not here.
So we'll go ahead and hear Mr. Upchurch, and then we'll defer Mr. Moore until after our break.
Okay.
Good afternoon, Mr. Upchurch.
Good afternoon.
The court reporter will now swear you in.
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Thank you.
Go ahead, Mr. Jeffries.
Okay. Thank you for coming, Mr. Upchurch. Like I said with the other ones, can you state your name and the position you hold with the city?
Ulysses Upchurch. At the time of your supervision, I was operations and maintenance crew supervisor.
Okay. You just answered that question. At the time of the accident, you received a call from me following the accident, correct?
Yes, sir.
Okay.
And Mr. Jeffries, if you wouldn't mind, just for my clarity, maybe others, would you talk about the date and time of the incidents you're talking about, so that we have that perspective?
That was December the 15th, I believe it was.
Yes, sir. December 15th. 22.
Okay. You came out to the scene, right?
Yes, sir, I did.
You had not a service specialist, you had a crew leader with you.
Yes, sir, I did.
Keith
Searles was the crew leader.
Okay. You did an accident report?
Yes, sir, I did.
Okay. Did you make I don't know if I should go into that yet. You understand what the progressive discipline is, right?
Yes, I do.
In this matter, did you know about any previous accident that probably would have progressed me into termination?
At the time of the investigation, I didn't. But as I progressed on, you have to go and check your service record. And once checking the service record, that's when I discovered that it would tie in.
Okay. Ultimately, the final decision, were you recommended to administer a termination, or was that purely your decision solely?
It was recommended to me at the time due to the circumstances that they felt, and I had to concur according to city policy and procedure of the progressive disciplinarian.
Okay. When a driver have an accident, an automobile accident, or even now I'm going to refer to just an automobile accident, sometime after that accident, that driver is required per departmental policy to attend a driver awareness training class, correct?
Yes. At the time, we had it set up to where in the departmentally that you would have to do that. We had the safety officer, and she would let us know at the time when you had to attend the class. And I think as a supervisor, I believe I had to be there as well in that class.
Okay. In any incidents, even including this one that you know about, I didn't attend that class, and I wasn't offered that class. Can you explain why?
To the best of my knowledge, I don't recall you attending it or myself, and I have no reason. I have no understanding of the reason why.
Why it wasn't offered to me?
No, I don't know why it wasn't offered and why neither of us attended. I have no recollection of why or ever attended it.
Okay. Did you ever have any other drivers under your supervision to go to a driver awareness class?
Yes, we did.
You did?
Yes, sir.
Okay. As far as drivers, not naming names of drivers, but just knowing drivers that you have, you've had drivers to have more than 2 accidents, correct?
Correct.
Would you say you have some drivers that may have had 4 accidents?
Fairly possible, based upon the timeline. They go back with accidents, go back to 2 years. So it's fairly possible that you could have someone within that, but maybe that accident was maybe 3 years or 4 years out, which
correct.
Totally could prize of 4 during the tenure there. But I was only in solid waste for 2 years. So
right.
Any previous ones to that I may or may not been privy to based on their record.
Not calling any particular driver name, like I said, you had one driver while I was the crew leader there that had 3 accidents. Would you say that's correct?
To the best of my knowledge, that's correct.
Was that employee terminated?
Not that I recall. I want to say they were demoted.
They were demoted? Okay. But they eventually went back to driving because that person is still driving?
I'm going to object. There's not enough specificity in any of this information to really be true evidence. I guess I'm objecting more. I think if they want to provide some clarity to what they're talking about, it seems very hypothetical at this stage.
So are you suggesting that they provide specificity on who this driver is and what his background is?
If
I didn't think that was correct to do that.
Yeah, hold on just one moment.
we typically don't ask for names, but we need something to link it to the relevancy beyond just the hypothetical. There may have been a driver kind of information.
Wouldn't the supervisor clarify that information to be true if it's coming?
Hold on just one moment, Mr. Jeffries. So I want to be really clear about what the city's objection is now.
What I'm saying is that this is very hypothetical. It's not hearsay, but it almost is, because it's talking about documents it's talking about records and disciplinary records without any evidence about it. It's out of court statements being brought in as evidence. That I'm more saying that without something in front of us, an exhibit to analyze or a way to look at the comparators that he's referencing, it's difficult to bring it into truth, if that makes sense.
Okay, so Mr. Jeffries, you understand what the objection is, and I'm going to allow limited testimony. If you can provide a little bit more specific information about this hypothetical that you're asking Mr. Upchurch, so that we're clear on the timing and so forth without naming the name.
Right.
Then please do so.
Right. That's why I didn't know if I could call out names, because you're not supposed to discuss any other personnel disciplinary action. So having the direct supervisor here to testify that this person did actually commit these violations. So that's why I wanted to ask him. That's why I have him here. It's not a hypothetical that the situation happened. It's true incident because the supervisor did the report on it.
So right now, what we have just your question and Mr. Upchurch, and the city's objected to say this is, kind of vague and not clear. And can you ask him specific questions so that it is clear, without naming names, the incident that you're talking about?
I can try, but I don't want to sound crazy. I'm not an attorney because I'm trying to speak around, not calling that person's name out. And that's why it's hard for me to, because if I speak around, it's like I'm talking into a hypothetical. And I'm trying to talk to truth, to actually what
happened.
happened.
I can't really help you figure out the question to ask, but I am going to ask you in your questioning to be as specific as you can so that we're grounded in, and this is not just people talking about somebody who might have said something about that's not specific.
Okay, I understand. Please correct me if I stray. Mr. Upchurch, you supervise drivers.
Mm-hmm.
You had drivers to have violations.
The one in question is EO3 driver, particularly that was reduced down to an EO2 driver because of the various safety violations and incidents, and they also our nature of work call for that person to still have to sometimes drive the EO3 when there were absences, if that's any relevance to what you're talking about.
If we had a shortage, you would, in an EO3, you would put him back.
He would have to go back
to an EO3, and you would pay him for. Okay, I'm sorry.
Yes, that's correct. If they were an EO2, which this person was demoted to an EO2, they were asked periodically to come back and drive EO3 routes based upon the need of the operation.
And when he did that, he was compensated for going to that EO3 position, correct?
Not initially. That kind of was not in play. It was volunteering on his part.
Okay.
But he had attended, as well as myself, he had attended classes to correct the behavior. So he had gone to the safety class that was set up for drivers that had accidents.
Okay, so that particular driver that we are discussing, he had a minimum of 3 within a 24-month period.
From my understanding, I was only in on the two. I think the one was prior to under my supervision.
But that information was still in his personnel file, right?
Personnel file.
So when you did the disciplinary action, you had to search his file in order to see that.
Right.
Did a recommendation of termination come out of that investigation?
No, it was recommendation determined was a demotion.
Was
A volunteer demotion on his end.
Okay. When you made the decision, even though you said you made that decision based on what was in the personnel file, was there a discussion with upper management concerning whether to do a demotion, or was the conversation was based on termination has to be done?
There was a discussion on my end questioning if we could do a demotion or not. And it was brought to my attention due to the number of incidents and what was in the file, purely that the strong recommendation was for me to do the term, to go into the preterm, which that was the resolve at the end of it. I had no other choice.
Okay, so you would say in my incident, I only had 2 accidents where one within a matter of months would have fallen off that you couldn't consider, correct?
Yes, sir.
So after 2 accidents that I had, it was a strong recommendation that I be terminated.
From my understanding, it was just recommended termination based on the number of incidents that happened. And there was a concern of safety that tied into the overall everything from what was discussed with me.
Okay. That's all I have.
How are you doing? Let's see. You mentioned the number of incidents. Could you clarify what you mean by incidents?
Vehicle incidents, not personnel per se, but vehicle incidents that occurred with various drivers, and in specific with Mr. Jeffries.
Okay. So you mentioned that you've had other employees with a couple more accidents than Mr. Jeffries have.
Correct.
That were not terminated
Correct.
as a result. When you look at these accidents, do you ever look at the circumstances surrounding the accidents and the behavior that may have happened before or after when considering the type of discipline that you put out?
Yes, as always, I mean, it has to be considered due to, the nature of our public service and what we do. So safety is paramount, and we are consistently, as I recall, and even now in my current role, we are consistently, looking at safety as a big thing. So, of course, that is taken in consideration.
So at the scene of this accident, you said that you were at the scene after the accident investigating it, correct?
Yeah, after the bump up, yes.
And Mr. Jeffries says, and I believe that you agree, that at the scene of the accident, he asked you if you would, based on this accident, recommend termination, to which you said no. Is that correct?
At the time, because I hadn't looked at his service record, so I had no idea how many or what was in his service record. So I was like, no, I wouldn't recommend termination based on one sole accident.
Sure. But it wasn't just one sole accident that led to the termination, correct?
After looking in the record and receiving the recommendation from my superiors, that was a conclusion, yes.
When you were looking into the record, were you only looking at car accidents?
Yes, that's the only infraction that we was dealing with at the time, was the vehicle accidents, the number of accidents from my understanding. But with the progressive disciplinary action, it wouldn't have mattered. That's the only thing that I recall he had that I was looking at was the vehicle accidents.
So you were looking at the vehicle accident. What were you just referencing about the progressive discipline? Is that a separate track?
Well, not necessarily. I've seen it a couple of ways since I've been there, but let's say there's another violation or, for whatever reason of misconduct or something like that, with the progressive discipline, all of that would be considered. So if there was misconduct in a vehicle accident, then misconduct in a vehicle accident, all of it is progressive from my understanding.
So even in situations where accidents may occur, other types of misconduct can be considered when making disciplinary decisions, even arising out of a vehicular accident, correct?
Probably, yeah. In most cases, because I've even seen, even in particular Mr. Jeffrey's case, per se, that one of his particular disciplinary actions, I think it was conduct, instead of it going to preterm, it was reduced to just a write-up, a final write-up instead. So there's, between the HR business manager, management, collective of evidences and investigations make that determination.
So with the 24-month period that is being referenced, that's looking at vehicular accidents that have happened in the past 24 months, correct? Within that one standard operating procedure?
Well, that's the one disciplinary action that'll stay on the record from what I was trained to be on is 24 months. Conduct and things of that nature may be only 1 year.
Okay, so if you are looking in the past, if you're following the one track, the accident-only track,
Right.
then you would look at the past 24 months, correct? But
Yeah, I would have to.
But if there are other instances of misconduct beyond just the traffic accidents, then you look at the whole record as a whole.
Yes, sir. That would have to be considered.
Okay, no further questions.
I have one question. In that scenario, what he's talking about, if you have an automobile accident, then within that 24-month period, say for instance, a couple of months afterwards, and then 18 months later, you could only consider that automobile accident not the write-up because it fell outside of the scope of that 1 year annual evaluation, correct?
Yes, that's possible depending on if you have 3 accidents within a 24-month time frame, that could be considered highly, a high risk.
Right.
I don't recall, and I could be corrected, stand to be corrected. I don't recall a number of accidents being the tell-all for termination. Like if you have 4 or 5 or whatever, I don't recall there being a maximum number. But I do know that progressive discipline in the track of once you get to a final, the next step is going to be pre-termination. From my understanding, some people may be on a final and then the next is pre-term.
Right. On that, what you're just saying, there is a accountability. According to city policy, is after the 4th accident, a driver can be terminated. After the 4th accident. And after the 5th accident, within that 24-month period, he's most likely terminated on the spot, from that 5th accident. So there is a level of progression of discipline when it comes to vehicle accidents. The point I was trying to make is that if you was considering termination through progressive discipline, that even that final written warning had to fall within a year of making that determination of a termination. If it fell outside of that 1 year evaluation, you couldn't consider it.
Right, correct.
Okay. That's all I have.
Any questions, any further questions for this witness? Thank you very much, Mr. Upchurch.
All right, thank you.
Yeah. So we'll take a break now. It's 12:35. Let's come back in, if we can, say 1:20, something like that, if everybody's comfortable with that. And so we're going to be in recess until 1:20. Thank you.
he could talk about how it could be considered, or how he conceives that it was considered by our
When you
supervisor.
say he can talk about that, are you talking about
Mr.
Moore?
Jeffrey, but calling in people to talk about the facts of specific prior instances that were not properly appealed is outside the subject matter jurisdiction of the hearing today.
And Mr. Jeffries, was the incident that you want to question Mr. Moore about appealed?
It was appealed to Mr. Joseph, and Mr. Moore did come forward with a statement saying that it was his responsibility. After that, I was not notified that I had another step. I thought the decision and the grievance process stopped with the director of solid waste. So he made his decision that he wasn't going to hear it, and he was going to stand with the discipline that was given to me, even though I was nowhere involved in driving that vehicle.
Mr. Ridgway, you have a response for that?
Very, very quick. Well, one thing. I made a mistake. I said that it was in May of 2019. That was the Taco Bell one. The front end loader was in February of 2020. And I'm sorry, could you repeat the question that you had?
Do you have a response to what he just said about his lack of notice of the appeal process?
I'm trying to look through my exhibit real quick to see if it is written like in every other correspondence that he's gotten during his appeals process that says the appellate deadline and the appropriate party to appeal to. And so I need just a moment to look through my exhibits. I don't have a response. It's fine. We can take our break.
Okay. So at this point, I'm going to allow Mr. Jeffries to question Mr. Moore, and if at that time you have other objections, I will certainly hear them. But at this point, I don't have enough to completely rule out the possibility that Mr. Moore would have something relevant. So I'm going to allow the testimony. We'll take a break, and when we come back, you can call Mr. Moore.
Okay. Wait, but is Mr. Moore appealing virtually? Is that what you were saying earlier? That Mr. Moore is not here? And
I'm trying to figure out how to get his testimony in.
Right.
Oh, he's not here.
No, he's
no,
not here,
he's
and
not
he
here.
was saying he went home for the day sick.
Well, he
or-
said
Another
he
reason
said he
we'd
was
object.
coming.
Yeah.
He said he was coming to the hearing, but I don't know. I need to call him again. My phone was vibrating. It may have been him.
Okay.
But during the break, I'll reach out to him.
Okay. So he will need to be here to testify because we've not made arrangements to have his testimony any other way.
Right.
So during the break, if you want to try to reach out to him and make sure he's here, then we will hear his testimony subject to further objections from the city. And at that point, we're going to recess, and now we're a little bit later. Let's see. So let's just take until 12:30.
1:30.
And 1:30, sorry. Thank you. The Civil Service Commission is back in session. Mr. Jeffries, call your next witness.
My next witness is Mr. Cameron Hill.
Sorry, what was that last name?
Cameron Hill.
Good afternoon, Mr. Hill. The court reporter here will swear you in.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay. Mr. Hill,
Yep.
thank you for coming. I guess state your name and the position that you was holding at the time.
My name is Cameron Hill. I was a sanitation worker with the city of Raleigh.
Okay, you were a service specialist working on the vehicle, correct?
Yes.
And your job included riding on routes, assigned routes, and collecting refuse on that route.
Yes.
Were you trained to do the job that you was doing?
I was.
You were.
Yeah.
Did you go through any training classes on how to be a service specialist or spotter?
No.
You didn't go through any classes?
No.
Okay. You were my service specialist on that day. You had worked with me several times before on routes, correct?
Yes.
So we
Mr.
had.
Mr. Jeffries, hold on just a moment. Make sure you identify which day that we're talking about so we're all on the same page.
Okay. This was it December the 15th?
2020. With him on your truck. Yeah.
Right. So during that time, pretty much you became my primary spotter at each stop if I had to back up, correct?
Yes, that's correct.
The reason why, because I felt that you were a strong service specialist, strong employee, and I trusted, your judgment when you did that. Each time that we service refuse, if I had to back up, we had discussed where to position yourself in order to back me up, correct?
Yes.
On this day of the accident, and there is, I guess, it's in here, of the pictures of the cul-de-sac?
His pictures, the diagrams that he drew in the accident reporting procedures are, the diagram that you presented to me is not in exhibits.
It's not. You had that on your phone, right?
I know what you're referring to.
I was just trying to make sure they got a visual of the area. They may can get it through that picture that he drew.
So it's up to you. This is your case. So if there's something that you want us to see, you can either have it in the exhibit book, or if you've shared the exhibit with Mr. Ridgway prior to this, you can use that.
Okay. Yes, I do want you all to see that area. I just have to find it.
Exhibit 15 in the binder that I gave you should have some of the pictures.
Mr. Ridgway, you said that was 15?
Sorry, my numbers are different than your numbers are. Let me see.
Because the reason why I said that is because Cameron's depiction and Burton Reed, which was the other specialist, there's kind of different.
I think it would be 27 in the ones that you have.
Okay, I got it.
But Mr. Jeffries, you're going to have to direct the witness based on that exhibit book.
Okay,
that's
yeah.
the one he got in front of me. Just a note.
You have that's in there, right?
It's in here.
On that one, it will be, hang on, sorry.
I think you said 15.
That sounds right, yeah.
Looking for the pictures of the.
Looking for my exhibit list.
I'm confused.
11 and 12 in
11
that
and
one.
12.
Okay, Mr. Hill, when we first pulled into that cul-de-sac, we had serviced several houses before we got down to that vehicle, correct?
Yes.
When we got into the cul-de-sac, you and Mr. Reed dismounted the vehicle, right?
Yes.
Okay, and we serviced that particular spot in that cul-de-sac, the first spot.
Yes.
After servicing that spot, you and Mr. Reed were walking over to that next spot where the vehicle was.
Yes, that's correct.
After maneuvering the vehicle to the position to back up, you had positioned yourself to the right-hand side of the vehicle, right?
Yes.
Okay. Once I checked the surroundings, like once I first came in the cul-de-sac, I checked the surroundings. When I stopped, I looked at you and you gave me the signal to start backing, correct?
Yes.
I maintained visual eye contact with you through that passenger side mirror, correct?
Yes.
Even though I did check my mirrors, Mr. Reed was far to my left. He wasn't a spotter. He was walking over using his telephone. He was on his phone, correct?
Yes.
So you were my primary spotter.
Yes.
When I backed up to the point of making contact with the vehicle, you stated that you were saying stop, stop, stop.
Yes, I was.
Okay. On the rear of the truck, and I think that's one of the displays too, there's a buzzer for the service specialist to notify the driver to stop or just to get his attention. That buzzer is only used when the service specialist is on the truck. You didn't press that service button, did you? Because you was on the ground?
Yeah, no.
Okay. The only way that you tried to communicate with me was through hand signal and to yelling out.
Yes.
To stop.
That's correct.
Okay. The vehicle is kind of loud when you're riding on routes, correct?
Yes.
And if the windows were up on the vehicle, you would think that it would be hard for me to hear a verbal command, correct?
Yes.
Due to the engine noise.
Yeah.
Upon making contact with the vehicle, I stopped, correct?
Yes.
Stop the vehicle. I got out and I came to you, and I was like, what happened? And your first statement to me was, you didn't realize that that car was that close to the vehicle, correct?
Yes.
Okay. And you said you apologized.
Yes.
Okay. And I told you accidents happen, you know, people have accidents. And so I did say that. In this incident here, do you feel partly, even though the responsibility, like I had stated before through the witness earlier, is that the safety operation of that truck falls on every member of that truck, correct?
Yes, it does.
Do you feel not total, but somewhat responsible of this incident happening?
I would say I don't feel fully responsible because it wasn't. I'm not saying it was my fault, but I'm saying it wasn't my fault because I tried backing you up as good as possible. Best I could.
But you would say that you probably felt somewhat part responsible.
Yes.
As a primary spotter.
Yeah. Yes, sir.
Okay. Do you recall receiving any disciplinary action?
No.
On this? Okay. Were you aware that Mr. Reed was trying to stop me or use the buzzer on the vehicle?
I wasn't aware.
Okay. So you would say the only commands that you were able to get across to me was the hand signals, correct?
Yes.
And you made the statement that I must have not have heard you.
Yes.
You stated that you saw the car when I was first pulling back, but the car eventually was out of sight because of the truck.
Yes, and I tried to, stop you with my hand.
Okay. So when the truck came in contact with the vehicle, you didn't see that?
No.
Okay. You were asked by Mr. Upchurch to write a statement of the accident, correct?
Yes.
And I was reading your statement. There was some marking on it, and I think the drawing. Did you? I think this drawing here has got your name on it. Did you draw this?
What page is that?
Is there a date on that?
It says 1/27/21. 7 a.m. I don't know who wrote that. I don't think.
I can clarify what that is.
Okay.
That is a drawing. That drawing was done during it was done by Mr. Hill during Mr. Joseph's investigation later on, but it is from Mr. Hill. It just was not taken. This one drawing that he's showing was taken at a later point, to my understanding.
What drawing are we talking about?
There's a diagram that Mr. Jeffries is showing right there.
Okay.
Is
that in evidence?
It's in a different exhibit because
Is it in this book?
I believe it is. Yes.
Okay. Can you locate that for the commissioners?
Too sure what page.
You trying to see it?
Yeah.
Go to page 35. That's a couple of pages back after that.
I believe it's Exhibit
It's 21 within Cameron's.
Oh.
21, last page.
Yeah.
Last, yeah. I have this last page of 21.
That's Reed's diagram, and then there's Mr. Hill's diagram earlier.
21, there should be two drawings, one from Burton Reed and one from Mr. Hill. But I'll let Mr. Jeffries continue.
Yeah,
I didn't mean to.
Mr. Jeffries, point out to us what we're supposed to be looking at.
Okay, I was.
And hold on, and let Mr. Hill know too. And
Okay.
Yeah. Go ahead.
On this drawing, do you recall drawing this?
And,
Yes.
And hold on just a moment. And if you would, please, Mr. Jeffries, point out to us which drawing you in that exhibit book, which page it is, so that we're
Okay.
all looking at the same thing.
Well, I think your page is different than mine.
But in the exhibit, can you either hold up or I just want to make
I
sure
will.
we're looking at the right thing.
Okay. You said you do recall drawing this?
Yeah. I think so.
And pause one more time. Mr. Jeffries, are you talking about a drawing that has Mr. Hill's
Name on it?
and then 12721?
Yes.
Okay.
You said you think so, or did you draw it?
The picture I drew, it looks similar to this.
But is this the particular picture?
It might be.
But you're not sure.
I'm not sure.
Okay. The accident occurred on December the 15th. This drawing was on January the 27th, which was a whole month later. Can you explain to me why?
I'm not sure. Truly.
Okay. Madam Chair, I'm going back to his statement now. That's marked 12/15/2020.
And I believe in the city's exhibits, that's just one, one page behind where,
Right.
where we were.
Yes. I see 11:30 a.m. was approximate time that the accident occurred, around that time, correct?
Yes.
When did you write this statement?
I wrote the statement, I think it was in the morning, I think it was the day after.
Okay. Did you have any assistance with writing your statement?
Oh, no.
No? Who was with you when you wrote this statement?
I think Keith Searles and Ulysses Upchurch.
And thus, that's the supervisor and the crew leader, correct?
That's correct.
Okay. Did they talk you through your statement?
No.
No. This was all your words.
Yes.
Okay. Have you, as a service specialist, have you ever worked with a driver that utilized 2 spotters at one time?
Yes, I have.
And can you explain what that situation was that he used 2 spotters?
Okay, so for for example, if there's like 2 sets of yard waste on both sides, both of us will try to signal the driver on backing up.
So both of you?
Yes.
I was asking, at any time, did he use 2 spotters?
Sorry, I heard that. I thought you just said something. I guess you didn't.
In that situation, wouldn't you think that would be, do you think that would be kind of difficult to try to watch 2 people trying to back a vehicle?
Yes, in that situation.
And also that it would be unsafe
Yes.
to try to watch 2 people back while you're backing up a vehicle,
Yes.
correct? Did anyone talk to you about your statement after this?
No.
You didn't have a conversation with Mr. Joseph?
No, not that I remember.
Okay. You've worked with Mr. Reed a couple of times too, right?
Yes.
How do you view Mr. Reed as a co-worker on a vehicle, in your words?
Honestly, he's a pretty good worker, but sometimes he gets distracted with his phone.
So sometimes he is on his phone while working.
Yes. Well, most of the time. Or sometimes he'll go in the truck and get on his phone.
So you would say that wouldn't be a safe, a good habit to have while working on the truck?
Yes, it's not a good habit.
In this incident, do you think that Mr. Reed was distracted?
Yes.
Okay. I think that's all the questions I have at this time.
Mr. Ridgway?
Would you elaborate a little bit on your statement that using 2 spotters could be unsafe?
So when there's so for example, if there's like 20 bags on both sides of the house, then one person is going to be on each side and trying to stop the driver from backing up too far.
How would that be unsafe to have 2 spotters to help stop the vehicle compared to just having one?
How would it would be unsafe?
How would it be more unsafe to have 2 spotters helping back a vehicle in that situation compared to just one?
It wouldn't be.
It would be. Would you say it would be more safe to have 2 spotters helping?
Yes.
Okay.
I object.
You'll have your opportunity.
Okay.
Let the city go forward.
In a later interview with Mr. Stan Joseph about this incident after Mr. Jeffries appealed it, he had a follow-up interview with you. Is that correct?
Not that I remember. I don't think I remember that.
Okay. Did you ever indicate that Mr. Jeffries may have been moving a bit too fast?
Oh, no, he wasn't.
Would you say that he hit the gas pedal at all during the backing process?
No, he didn't.
And you said that in your time, could you please clarify when you were working as a spotter for the city, or working in the solid waste services with the city in a similar role?
Well,
like 2018 to 2020. About how long were you working with the city?
It was 3 years
Around
since 2019.
And during that time, you've been in situations where 2 spotters have been utilized?
Yes.
Okay. How often would you say that happens?
Frequently. Yeah, frequently.
And I know that you're not a driver, but I imagine that you maintain eye contact with drivers during this time, correct?
That's correct. But sometimes, well, there's different drivers who uses 2 spotters, and there's other drivers who use 1.
Okay. When you were behind a vehicle and you're trying to keep a visual lock with the driver through the rear view mirror, is that correct?
Yes.
And what's a driver supposed to do if they don't see you in the rear view mirror?
They would sound their horn, and or they would just stop the truck.
Okay. Then you said that you used hand signals during the 12/15/2020 accident, that as he was backing up and you saw that he may hit a car or an object, do you mind, and may the record reflect, do you mind showing us the hand signal?
Yeah, so so I was trying to back him up slowly, and I guess like he didn't see when I raised my fist to stop the truck, because I didn't see the vehicle afterwards.
Why do you think Mr. Jeffries didn't see your fist?
I'm not sure.
If a driver can't see his spotter, to your understanding, what are they supposed to do?
They would stop the vehicle right away.
Is that what happened in this situation?
No.
No further questions.
Yeah, one of the questions I felt and I'm not an attorney, that he was leading Mr. Hill to say what he wanted him to say about the two spotters. So he was saying, so you would use two spotters, so you would say that would be safer, when he had already stated that some drivers use one and some drivers use two. Sometimes it could be unsafe to use two because the driver is basically distracted trying to keep up with both spotters at one time.
So I understand that you are now objecting to him leading, but he is, this is your witness, and the city can lead your witness.
Okay.
If you have another question for him, that's fine.
Okay.
But the
understand.
city's manner of questioning was fine.
Okay. You did say that at some times drivers have different techniques when backing a vehicle, correct?
Yes.
Some use two, some use one, correct?
Yes.
Some spotters stand on the driver's side of the vehicle, and some drivers stand on the passenger side, correct?
Yes.
There is no wrong way about that, correct?
Yes.
So it's the communication between the driver and the service specialist,
Yes.
okay? And the communication that you and I have is where you were standing, correct?
Yes.
While you was there as the spotter, making eye contact with me through the passenger side mirror, you may have saw me turn my head to the left and then turn back to you, correct?
Yes.
So you would say that it would be important for a driver to continually move his head to see what his surrounding is, correct?
Yeah.
This situation here was purely what it was, an accident, correct?
Yes, it was an accident.
Do you think that anything was done careless in this situation?
No.
I have no further questions.
I have one. So Mr. Jeffries and you, through the line of questioning, mentioned that before you guys sort of discussed or at least figured out where you would be standing prior to you getting behind the truck and the truck moving. Is that correct?
Oh no, I just he never told me to jump off. I just jumped off.
Okay. But Mr. Jeffries, you utilized him as your primary spotter.
You asking me the question?
Oh, I guess I'm sorry. That might be improper, actually. When you were standing behind and getting positioned, you said that you couldn't see the car because the garbage truck was, I guess, blocking your view of it. Is that accurate?
Yes.
Is it true that you knew that the car was in the cul-de-sac before you guys got there? Or
Yeah.
as you pulled in, you saw the car that was there?
Yes, I knew, but when we started backing at a certain point, I couldn't really figure out where the car was at.
So,
and I thought Reed had knew.
So you thought that Mr. Jeffries was utilizing two spotters, was your understanding at the time?
Oh, well, I wasn't sure.
Okay, so as his spotter, you stood somewhere where you couldn't see the obstacle that was in the cul-de-sac that you were essentially guarding Mr. Jeffries from hitting. Is that correct? As you were spotting him?
Yeah, I knew where the car was at, but it was a certain point where I didn't, and I thought Reed had knew where the car was at
Okay.
and was trying to spot Mr. Jeffries.
Is that the moment when you indicated the hand signal for him to stop?
Yes.
Okay. Do you think that him relying on a primary spotter in that situation that was standing in the position that you were at was a smart idea? I can clarify if you'd like. So
Yeah.
you were on the back passenger side, correct? And
Yes.
This vehicle that ultimately got hit was on the driver's side.
Yeah, it was more on the driver's side.
And so one can imagine that a spotter standing across from the object at the angle that the truck is backing may lose visible contact with the object, correct?
Yes.
And when a spotter loses that sight of the object, or the driver see, hang on, I'm sorry, let me back up. Do you think that Mr. Jeffries could have done more in that situation to see the object beyond just relying on you?
Yes, he could.
What are some ways that you would suggest or conceive of him doing that?
I would see him probably stop the vehicle and in the middle of the cul-de-sac to get a better view.
Do you think checking the mirrors would be a good idea?
Yes.
Do you think checking the backup camera, if it was working,
Yes.
which it was, would be a good idea? I have no further questions.
Mr. Reed, like I said, you were my primary spotter, right?
Yes.
We gained a trust with each other working on the truck, correct?
Yes.
When you position yourself where you were, you could see the car at that time, right? When you first position yourself on the ground to back up to that location.
Yes, because we were sort of in the middle of the cul-de-sac, so I was able to
So
see it.
You were able to see it.
But at a certain point, I tried to get your attention.
Right. So at a certain point, the car went out of sight and you lost sight of the car.
Yes.
Correct. You said you held up a signal, which by the time you held your signal up to stop, the truck had already came in contact with the vehicle, correct?
Yes. The truck was sliding back a little too fast, but you weren't going fast.
Okay.
I guess it was.
Mr. Reed, at this time was distracted, correct?
Yes.
It possibly would have been safer if he was doing what he was required to do in this situation, correct?
Yes, by helping as well.
By helping as well. Okay. I have no further questions.
Commissioners have any questions? Do the commissioners have any questions for this witness?
Just a question of clarification. Thank you for being here. So, is it correct that you were making the signal to stop prior or after the truck collided with the car, or prior to it?
It was prior to.
Okay. Okay. Thank you.
Thank you very much, Mr. Hill. Do you have other witnesses, Mr. Jeffries?
I don't see him here. Mr. Moore had said he was trying to get here, but he was instructed to work on the route that he was working on collecting the stuff.
So are you planning to testify on your own behalf?
I can testify, but I don't have any exhibit. It would be better to hear from Mr. Moore himself in this situation because I don't want to say what Mr. Moore thinks or what he thought.
Well, we're here to hear the testimony, and if you have testimony that you want to give, regardless of what Mr. Moore might or might not say, this is your opportunity. I don't know. We can't hold open the hearing indefinitely waiting for Mr. Moore.
I understand.
So is there anybody in addition to yourself and Mr. Moore who you have to testify?
No, I don't have anyone else. I thought that the safety officer that we had, Tim Heath, would be here. I sent him an email, but I see that he didn't show up. He was the safety officer at Solid Waste at one time.
Okay.
So I would like to share testimony from myself as a witness.
All right. So if you're going to testify, we'll need to have you sworn as a witness.
Okay.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
So, Mr. Jeffries, go ahead and testify as you'd like.
Okay. What I wanted to say about what I was going to say with Mr. Moore and to get from his testimony is that when I was training with him, that accident that I feel shouldn't have been put on me because I was a trainee at the time on the passenger side of the vehicle. Mr. Moore made the decisions as a trainer on what he was going to do and how he was going to do it. Me never being on that particular vehicle before, I didn't know any safety rules or regulations concerning that vehicle. I had no knowledge of that vehicle. He was training me. So at this point, we were servicing downtown recycling dumpsters. The dumpster, Mr. Moore was driving, the dumpster fell inside of the truck, inside of the hopper. So the only way to retrieve it is probably through a wrecker truck with a chain to pull it out. So Mr. Moore drove the truck back to the facility and parked that truck because we had two vehicles that serviced those dumpsters. We parked one and got in the other one, and Mr. Moore drove out again and continued showing me stuff. He continued training me. In that time, someone was getting the dumpster out of the vehicle. So when we came back, they called and said the dumpster was out of the truck. We went back to the facility and switched back out trucks. So Mr. Moore said, well, I have to take that dumpster back downtown to where he had collected it from. So I parked one truck, and he got in the other truck and collected the dumpster. When I walked back across the parking lot, I saw the dumpster on the front of the truck. I was a crew leader at the time. The first question I asked him is that okay to drive that vehicle with that dumpster on the front of the truck? I said, can you see? And he said, yes, I can see. As a trainee, I was in no position to tell him that he was wrong, even as a crew leader or a supervisor, because I wasn't familiar with the vehicle. So when we left the facility to take the dumpster back, another supervisor saw us coming down the street with the dumpster on the front. So he called the superintendent, Griffin Hatchell, and told him that we had the dumpster on the front of the truck. Mr. Hatchell called my phone and said, hey, what are you doing? I said, I'm not doing anything. I said, I'm been training with Mr. Moore. And he said, why do you have that dumpster on the front of that truck? I said, well, I don't have the dumpster on the front of the truck. Mr. Moore does. I had nothing to do with that decision with him putting that on there. So he said, no, stop what you're doing. Bring that vehicle back to the facility. So when Mr. Moore was maneuvering the vehicles to go back to the facility, Mr. Moore eased up into a vehicle, not driving fast, but eased up and bumped the back of a vehicle and caused damage to the car. So we parked the truck. where we were off of New Bern Avenue, and Griffin Hatchell, my supervisor at the time his name was Takovi. They came to the scene to do the investigation of the accident. So I told Mr. Moore at the time, they're going to try to hold me responsible for this accident. I said, well, he said, no. He said, how can they do that? I was driving. I drove the vehicle. I hit the car. I said, yes, but just because I'm a crew leader, they're going to feel that I had more responsibility to stop you from doing it on a vehicle that I knew nothing about. So Mr. Hatchell directed my supervisor, Takovi, to write it up, and I was disciplined and demoted from a crew supervisor, I'm a crew leader, to a EO2 driver, to a regular driver. And I had nothing to do with that vehicle. So that's why I filed a grievance with Mr. Joseph. And in the end, Mr. Joseph upheld the decision that Mr. Griffin made, directing my supervisor to demote me for that incident. That incident helped progress to where I am now. They used that incident to say, hey, he had this accident, but I didn't have an accident. That wasn't an accident on my record. And I felt that it was unfair that Solid Waste Service, Mr. Joseph, Mr. Hatchell, to use that against me in order to do the progressive discipline to terminate me based on that and the other factors that Mr. Davis was talking about. So I felt undue pressure because I did file a grievance for harassment. There was other incidents, and like I said, we're not here to testify on that, but just what's at hand. But there was other incidents where I felt that I was harassed even before the demotion. Mr. Joseph didn't agree with what I was trying to explain to him about Mr. Hatchell. He said he didn't find sufficient evidence to say that he was harassing me, but it ended up being this way anyway because of Mr. Hatchell. So that's what I wanted to say about that, and that's Mr. Moore, if he was here, could testify because he did write a statement to me to give to my supervisor and Mr. Joseph. I gave them the statement, and he basically totally ignored because in that statement, Mr. Moore stated that every decision that was made during him training me was his decision, not mine. I never instructed him, hey, let me drive. Hey, don't do this or don't do that. I never gave him any instructions. I was a trainee, and that's what I was doing at the time. And I think it was just unfair in this situation where something like that is used to cost me my career with the city. That was stuff that could have been settled another way. As far as driver awareness, where Mr. Upchurch has stated, I was never offered a driver awareness class after an accident. It wasn't offered to me. So I felt that was unfair. And the only thing that I was asking is to be treated fairly as all other employees within the city of Raleigh. And this right here, having 2 accidents within a 24 months and not even given the opportunity to correct that, but just go straight to termination, I think that was totally unfair. I'm done.
All right, is that the extent of your testimony?
Yes.
Okay. Now, the protocol is that the city will now get to cross-examine you on your testimony,
That's
just like
fine.
the city has gotten to
I
cross-examine
understand.
other witnesses. Witness is yours.
I'll talk briefly about the front-end loader, or ask briefly about the front-end loader. How long was the training that you were doing on this front-end loader? Do you know? Was it multiple days?
It was multiple days, but it was no set time to say your training will be completed on this day.
But you had gone through multiple days of training.
Probably 3 days. I said because I did have an incident where the camera on top of the truck wasn't operable.
So, would in the incident report, it says that this was on the final day of your training here. Does that sound correct?
It doesn't sound correct. It may be what Mr. Hatchell had said, but he wasn't completely finished with training me. I had more training to do.
Okay, but as a crew supervisor, you do understand that you have an increased responsibility compared to lower level employees. Is that correct?
Yes, it is correct.
And given that you had worked for the city, you started in 2005, correct?
Yes.
So at this point, you've got about 15 years under your belt with the city.
Somewhat like that, yes.
And during that time, I'm sure that there were some type of safety protocols that you had learned either before or during your employment, correct?
We had safety training quite frequently. We learned a lot of safety issues.
So, given that you have increased responsibilities as a crew supervisor, even if not directly over a person training you, one could assume or imagine that the city may hold you to a higher standard than other employees who are not supervisory.
I disagree with that. I said because it depends on the situation. In this situation here, it was a new vehicle that I wasn't familiar with. I was being trained. So I can't say that I can agree that because even as a supervisor, we all miss something sometimes, one time or another, considering safety. And you could say a person can assume, oh, he should have knew better. But you can't know better unless you know better, unless you are trained. So if you're not trained with something, you can't. I wouldn't hold anybody responsible if they wasn't trained on that particular equipment and something happened, no matter if he was a supervisor or a regular driver.
Would you say that a reasonably prudent person would not attempt to operate a piece of heavy machinery with around 80% of its visibility obstructed?
And that was the reason why I questioned him when I first saw him with that in the front. When I first saw Mr. Moore with that dumpster on the front of the truck, the first thing I asked him was, do you think that that's safe, or can you see past that dumpster?
Did you stay in the car after asking that question?
Yes, because him as being an expert on that vehicle, it wasn't for me to question whether that was wrong or right, because he was the trainer. He was training me. So I was not in a position to say, hey, Mr. Moore, you're wrong on a vehicle that he's an expert on.
I'd like to ask a couple questions about the December 15th, 2020 incident. Why didn't you see Mr. Cameron Hill's hand signals?
One possible answer to that is that I was looking to see where Mr. Reed was. And it could have been at the time that I was looking to my left when I didn't see his hand go up to a stop position.
Would you say that you lost visual contact with your spotter at a time that it mattered most?
Anytime that you move your head from your spotter, you lose visual contact.
So was Mr. Burton Reed a spotter or not? Because, excuse me, yeah. Was Mr. Burton Reed a spotter or was he not a spotter? Because you seem to be flip-flopping a little bit back and forth on whether you were relying on him as a spotter or not. And if you saw him over to the side and he was distracted, why wouldn't you stop the vehicle?
The reason why is because Mr. Hill was my primary spotter. Mr. Reed was way off to my left on his phone. But as a driver, you will constantly check your surroundings. So Mr. Reed could have came in the area where I was backing. So at the time, Mr. Reed wasn't a spotter. He was just an employee walking across the cul-de-sac. Mr. Hill was my primary spotter, and that's who I relied on.
Why would you continue moving the vehicle if you took your eyes off of Mr. Hill and couldn't? Conceivably, he put up a hand signal that you didn't see. Was your view of him obstructed, or did you look away when he did the hand signal?
I just stated that that it could have been at the point where I looked to see where Mr. Reed was, see if he had came into the area and briefly and turned back to Mr. Reed, to Mr. Hill.
Why would the truck be moving when you're doing that?
Because it's part of driving. When you're back in a vehicle, your head is constantly moving. They tell you keep your head on a swivel. So constantly you're moving from left to right, looking at your mirrors. So when I looked to the right, I saw Mr. Hill. I knew Mr. Hill was in place. I knew he wasn't moving. He was in his assigned location. So moving the vehicle wasn't a hazard or a safety issue at that point. So when I looked over to see where Mr. Reed was for a safety purpose, I briefly looked over and looked back. By that time I did that, I had came in contact with the vehicle. That's when I saw Mr. Hill's hand up, but it was already too late.
You said that Mr. Hill was in his assigned position. I asked him this, but I'll ask you as well. Did you guys ever talk about where he should be? You guys had worked together before. Did you have a custom of him always being on the passenger side? Sort of walk me through how he ended up where he ended up and him not being able to see the car.
Right.
That he was the sole purpose of him standing behind heavy machinery to help you spot.
Just like what Mr. Leach had testified to, different drivers have different techniques. One driver may choose the left side to place his spotter. Another driver may choose the right side, whichever stronger side that the driver chooses. Working with Mr. Hill several times, he has worked on both sides. It just depends on where he is. Sometimes it's just not like, hey, Mr. Hill, go get on the passenger side and spot me. It's not like that. When you're working, you're constantly moving. Mr. Hill chose to go to that side, and that's the side I use. More times a lot of times, Mr. Hill would spot himself or place himself on the right-hand side of the truck. That's my stronger side. But either side is strong to me because I'm constantly looking both left and right. But my main focus is on my spotter. So that's how he just ended up. Not before he went to that spot, I said, hey, Mr. Hill, go and stand on my right side. I didn't do that. We worked as a cohesive team. When I see what he's doing, I play off of that. If I see him go to my right side, I focus on my right side. If I see him go to my left, I focus on my left. So it wasn't like we had a conversation at each stop to say, hey, go to this side, go to that side. That didn't happen.
But you knew where the vehicle in the cul-de-sac was this entire time. I understand that as you're backing up, you weren't trying to hit it, but you knew that the vehicle was in the cul-de-sac, correct?
I knew the vehicle was in the cul-de-sac when I first pulled in the cul-de-sac facing it. I knew where that vehicle was. But like I said, having strong reliability on my spotter to spot me, to avoid that vehicle, that's where my concentration was.
So your spotter is to your left. So you're looking at your left.
Which spotter?
Excuse me. Cameron Hill is on the
My right.
Okay. He's on the passenger side, and you're looking in your rear view mirror at him, right? Is this
side view?
Side view. Side view mirror. So presumably you're not looking at the side view mirror on the other side, which is where the vehicle would have been visibly seen, correct?
I do look at it. I did see it. But like I said, my concentration was on Mr. Hill because he was my primary spotter.
Instead of on the side view mirrors.
Say that again?
instead of scanning side view mirrors?
I did scan the side view mirrors. I scanned the mirrors. That's why I was looking for Mr. Reed on my left side. When I looked for Mr. Reed on my left side, I looked to my left mirror. When I turned back around, I wanted to make sure I maintained eye contact with Mr. Hill.
In backing up, was the car ever visible in your side view mirror on your driver's side?
Yes, it was.
How did you not see it yourself without relying on the spotter?
Because I was relying on my spotter and I was moving my head. I looked to the left, like I said, where Mr. Reed was, to see where he was located. I saw the car on the left side, but the main focus is on my spotter that's standing behind the rear of the vehicle to keep from hitting him. I knew that Mr. Reed was safely out of the way. He was right at the back of the truck, so I couldn't lose too much focus off of him being on that side of the truck and the truck backing up.
Again, it sounds to me that he was on the wrong side of the truck, and I'm trying to figure out why your focus was there instead of on the objects if he was a safe distance otherwise away from the vehicle.
You stated that it seems to you. As I stated before, a professional driver have different techniques. So you can't say that Mr. Hill was on the wrong side of the truck. That's what we work off of. He placed himself on the right-hand side of the truck, and I used that as my focus.
But ultimately, who's responsible for the truck?
Ultimately, the driver is responsible for the truck, but as a team, all people on the truck is responsible for the safety operation of the vehicle.
I'll give a hypothetical. Let's say that you have 5 safety tools that you could use in a given situation, and you choose to use 3 of those safety tools. 2 you could have used, but didn't feel the need to, whatever happened, and then an accident happens. Would you expect people to question why you didn't use those 2 extra tools that could have prevented the accident from happening?
I'm pretty sure anyone would question that, but through the, I guess, explanation of what happened at that accident and what the accident report shows, it'll show that I did use the tools that was at my disposal. Because I didn't use to doesn't say I did anything wrong, because I did what I was required to do. My spotter was placed in a location to back the truck up. My other spotter was to my left in a safe spot.
Was he a spotter or was he not a spotter?
At the time, he wasn't a spotter because he was walking from one location to a different location on his cell phone. So I couldn't use him as a spotter. As Mr. Hill testified, is he felt that Mr. Reed was distracted with his phone. That's what he testified to.
And you didn't think, as the driver who's responsible, to ask for your secondary spotter to get off his phone?
I don't use 2 spotters. I use 1 spotter. That was my technique. I wasn't in a situation where I needed 2 spotters. He was standing next to the refuse to be collected. That was my focus on Mr. Hill because he was there.
But you understand why I'm questioning why you didn't use all the safety tools available to you. You had 2 people there who were trained to be spotters, and you utilized one while allowing the other to be distracted on his phone off to the side.
Because the other one wasn't an important factor at the time because he was safely out of the way. So him being on his phone wasn't an issue.
Do you think that had he been able to be paying attention and been in proper position as instructed by his driver, he probably could have helped you avoid the car?
I still, at that time, even if he wasn't on his phone, wouldn't have relied on Mr. Reed because one is him being between the truck and the car itself would have been a safety issue also because he could have got crushed in between the car and the truck. Mr. Hill was in the better position at the time if he could have maintained maintain sight with the car. But like I said, you keep saying, well, shouldn't you have used Mr. Reed? No, even if Mr. Reed wasn't, because I normally use one spotter, and Mr. Hill was my primary spotter, so my focus was on Mr. Hill, not Mr. Reed.
I understand, and what I'm saying is that if Mr. Burton Reed, I understand that you normally use one spotter. I am asking you, do you think that is an overstep on your part, maybe overconfidence on your part, to not use an extra safety resource that Mr. Burton Reed, had he been properly paying attention and in position, would have provided you?
My stance is still, and I maintain, that Mr. Reed was not a factor in backing this vehicle up. Can I finish, please? He was not a factor because he was out of the safety zone. He was out, he was safe where he was, even if he was distracted on his phone or whatever. Even if he wasn't, I still wouldn't have used Mr. Reed because my confidence level was more on Mr. Hill than I had on Mr. Reed. Yes, I could have used Mr. Reed as a spotter if I chose to, but I never used two spotters. It's either was going to be Mr. Reed or Mr. Hill, and sometimes Mr. Reed did. I did utilize him as a spotter, but at this time here, he wasn't a factor in the situation.
Just hold on just one moment. Just observation, we're sort of plowing the same territory again and again, and wanted to get a little bit of clarification from you. We're going to have a break soon. How much more do you think you have with this witness?
I'm about done cross-examining. Okay. I think that my question for you is, why do you continue to use one spot? Like, why use one spotter if you could use two?
Again, I say different drivers have different techniques. My technique was to use one spotter, someone that I trust, someone that I utilize, I guess, 80% of 100% of the time, that I go to this man because I trust him more, because I knew that Mr. Reed was always distracted with something. Either he was on his phone or, like Mr. Hill said, inside the truck not working. So I didn't make Mr. Hill a part of the problem. I didn't need to use him. I had one spotter, and that's as a driver, that was my technique, to use the one I trust the most.
I'll end my questioning on that. Yeah.
Anything further you have to say? I think we've been through this topic a lot. Is there anything further you have to say, Mr. Jeffries?
I don't. Okay.
And do you have any other witnesses?
I don't. I guess Mr. Moore didn't make it. I don't have any more witnesses.
All right. And are you ready to rest your case?
I am ready to rest my case.
I have a few questions.
Okay. Yeah. Please go ahead.
So not to go back to the beginning of this, but I'm reading through your request for administrative hearing before the Civil Service Commission. And the Civil Service Commission, we have very set instructions that we have to follow. So we're not an equity board, we're not a fairness board. We have very specific things. And so in the commission bylaws, it says the commission shall hear all appeals of employees regarding violation of city policy. So reading through your request for hearing, I don't see specific policies that you're accusing the city of violating. So is there a policy other than I was dismissed without proper justification? That's not a specific policy that I'm aware of. So are there any specific policies that the city violated in your termination?
Yes, I don't have them with me. I had some, but it is a violation when you go outside the scope of disciplinary action to move to progressive, to move something forward, that they went beyond the annual evaluation period to use something to terminate me. And like I said, I filed a grievance with the city concerning the incident with Mr. Moore.
Sure, but we can't hear that in this case because that wasn't appealed to us. And so So do you know the policy numbers or anything that say that they shouldn't consider many of your accidents or whatever? Like, do you have those policy numbers that we can review?
I mean, as part of it is 300-14, but I don't, like I said, I don't have it with me, but there are violations that I feel that was done in order to consider this, this action.
You know, because the other concern that I have is that, in our bylaws it says that the violations have to be in the initial appeal, and I'm a little lenient on that based on the city employees' understanding of the process, but I just don't see any specific policies that you're alleging that the city violated, and even now I don't know if we can get those policies or those numbers. That's where I'm struggling. So that's kind of my question, and I'll stop there.
Are there other questions from commissioners of Mr. Jeffries?
Oh, just one. So if I understand your testimony correctly, so was Mr. Reed ever in the position of spotter, if you will, just in that general area?
Not in this area, because Mr. Reed, as Mr. testified, he was on his phone. He was walking across the cul-de-sac. Even though I saw in his statement said he was trying to stop me to press the buzzer, none of that happened.
Okay, yeah, I'm just a bit confused because both Mr. Hill and Mr. Reed's little diagram kind of shows him in that general vicinity.
Right.
So I'm not sure if he was in that area at the time of that incident or if he was just walking towards that area.
I would put it this way. Mr. Reed knew that if the supervisor knew that he wasn't close to the truck and he was on his phone being distracted, he possibly could have got some disciplinary action. And that's why I believe that he put this in there, that he was next to the truck. But like I said, as the testimony from Mr. Hill, he was not on the other side. And at one point, when the truck backed up far enough, he couldn't see Mr. Reed anyway.
Okay. Yeah, and to the best of your knowledge, were you ever trained that you need 2 spotters when backing up the truck?
Never. Even Mr. Leach alluded to that also, that he always used 1 spotter. Right. We never use 2 unless it's a special circumstance that you may want to use two spotter, which I feel, and I think he was saying too, it could be a little unsafe because you're going to lose focus off of one of your spotters. And that is the main reason why you would use 1 spotter and not 2.
And to the best of your knowledge, that's not really written in city policy or just. Yeah. So to the best of your knowledge, it's not written in any of the city's policies or solid waste policy.
It is to use 1 spotter.
But not a mandate that says you have to use 2 spotters.
No, there's no mandate to say you have to use 2 spotters.
Okay, thank you.
Any other questions for Mr. Jeffries? All right, we'll take a 10-minute break, and then now that I understand that you've rested your case, the city will have an opportunity to put on its case. Before the city, I think you have now the opportunity to put on your case. I think one of the commissioners had a comment to make.
Yeah, I just kind of want to share my thoughts with the rest of the of commissioners after hearing the petitioner's side of the case, and I just have concerns. Because I'm a lay person, right? I'm not an attorney by trade. I barely graduated high school, so I'm not a very smart man, right? And so when I see people come before the Civil Service Commission, I always tend to err on the side of grace when reading their complaints and stuff like that, especially as a city employee trying to navigate this process, it can be daunting. And so if in the initial petition to come before us, there isn't an explicit claim of violation of city policy, I tend to err on the side and give them a little more grace and hear their side of the story. And so, but after talking with Mr. Jeffries, I just have concerns about our subject matter jurisdiction on this case because in the original complaint, there's no specific alleged violation of city policy other than just a wrongful termination, which is very vague because we know the specifics of every termination are different. The specifics of every accident or number of accidents are different. And then in asking the petitioner, a few minutes ago, has he had time to think about a specific violation of city policy? There was some vagueness, and there was nothing that made me feel better about a specific policy that the city of Raleigh violated. And this board is not a board to review, past disciplinary actions of other employees or past disciplinary actions of the petitioner and such like that. So I just wanted to voice my concerns of my serious concerns of the subject matter jurisdiction and if we should even be hearing this case at this point. So I just wanted to put that on record.
All right, thank you.
Are we?
No, you may either answer now. We're not at the argument stage. If you have evidence that you want to put on, you're welcome to do that.
I wanted to enter a motion into the record.
Okay. You may enter a motion.
The city would like to move for a motion to dismiss. He kind of beat me to the punch on it a little bit there, but the commission only has jurisdiction to hear things properly appealed before it. There's not, let's see. There's not an allegation of a specific policy that has been violated under the best evidence rule. We need a written policy to look at. We have not been provided one. We've heard vague gestures at something that Mr. Jeffries perceives to be unfair, but he has not pointed to a specific policy. He has not pointed to a specific procedure, and in not doing that, I think that he has deprived this commission of jurisdiction, and so that's my motion for the commission, and I look forward to your comments.
So, Mr. Jeffries, do you understand what Mr. Ridgway has just said? So we are now at a stage where we've been asked by the city to entertain a motion to dismiss the case without hearing the city's evidence. And you're welcome to argue that point at this point, and if you'd like to do that, we'll hear you. And then I'm going to go ahead and allow the parties or the commissioners to discuss that motion. You don't have any further argument on that point. All right. So before the commission is the city's motion to dismiss for lack of jurisdiction. Is there just other discussion among the commissioners on the city's motion? All right. Hearing none, do I hear a oh, go ahead.
I was going to move that we grant the city's motion to dismiss.
I second.
All right. Any further discussion on that point? All in favor of granting the city's motion to dismiss indicate by so saying aye.
Aye.
All right. So, Mr. Jeffries, your appeal has been heard and dismissed for lack of jurisdiction. So I want to appreciate your coming today and appreciate very much your testimony. And with that, this hearing is recessed or ended. Adjourned. Thank you.